This is a matter regarding employment under the rehabilitation and resettlement policy of 2016, my lord. The petitioner is a land loser, wherein I have given the certificate. Kindly have a glance to Annexure 8, my lord.
So the opposite side parties have not been served.
The IOCL would be the Indian Oil Millers would be the
OP number 4.
Requisites not yet received. You've not filed the requisites for more than 10 years, sir, now.
My lord, the order dated 6/9/2011, government has taken time to file the counter.
No. If only government is the relevant party, Indian Oil is not the party.
Sir, my lord, collector is there, my lord.
No, you're dropping Indian Oil then. Should I say that you're dropping Indian Oil? Where do you want him to be appointed in the government?
Under the OP number 2 and 4, my lord.
So if they are not served, then how do you proceed in the matter?
But the resettlement policies of the government, my lord.
So you make up your mind, sir. If you want to drop 2 and 4, we can drop them.
No, my lord. Otherwise, I am ready to take a fresh notice, my lord.
This is a 2011 matter, sir. You should have filed requisites by 2012. For 10 years, you've not filed requisites at all. It is listed because we've asked old matters to be listed. Otherwise, you're not interested in the matter, it seems.
My lord, I am out of employment, even though I am coming under this specific category. I mean, take fresh steps, my lord, within 2 days.
For over 10 years now, requisites have not been filed for service of notice on opposite parties 2 and 4. Mr. Manthi Leonard comes, the petitioner pleads for one more chance. Fresh notice on opposite parties 2 and 4 returnable. 21st September. The notices be sent by speed post and the tracking report be placed on record. Counsel appearing for respondents 1 and 3 prays and is granted 4 weeks time to file a reply. Rejoined up for the next date.
Weekly list item number 2.
Obliged.
Your Lordships, on behalf of Mr. Jana, the matter has become infructuous.
Counsel, the petitioner, appellant states the petition, the appeal is rendered infructuous. It is disposed of.
Weekly list item number 3.
May I please, my lord? My lord, here.
What's the delay, sir?
My lord, delay is. My lord, the Honorable Single Judge pronounced the judgment on 7/3/2021. I'm sorry, my lord, 7/3/2012. I filed on 27/2/7/2012. That is delay of 4 months. Around.
All right. Yes. Tell us.
Here, the petitioners, the appellant before your lordship, were initially the inhabitants of under village Dumuria under the princely state of Kharsua. Kharsua was under this after the merger of the princely states were abolished. They became under the state of Bihar. Thereafter, they migrated to the state of Orissa. In the state of Bihar, my lord, they were recognized as scheduled tribe persons, scheduled caste, my lord. And this caste is also included in the caste in the state of Odisha also. They purchased a property from another scheduled caste. After a long years, the original vendor being dead, the legal heirs came up and filed an application before the Tahsildar stating, in the meantime, mutation, everything was done. They filed an application that there is no permission under section 22 of the Odisha Land Reforms Act. So the sale itself was invalid, which was stood confirmed till High Court. Before this honorable court, while dealing with your lordship, will see the impugned order, page, my lord, it is page internal page 3, paragraph 5. My lord, paragraph 7 at internal page 4. The factual aspects of the case are not in dispute in this writ petition that the petitioner is residing in the state of Orissa for last 20 years and also scheduled caste certificate has been issued in favor of his daughter. The petitioner originally belonged to state of Bihar, migrated from Bihar to Orissa. He is now residing in Orissa. He belongs to scheduled caste so far as the state of Bihar is concerned. However, he cannot claim same benefit in the state of Orissa as are available to scheduled caste person in the state of Bihar. The president in the year 1915 exercised the powers of Article such and such has notified the scheduled caste and scheduled tribe respectively in states of Bihar states after consultation with the governors of the respective states by public notification. The said presidential declaration subject to amendment by the parliament being conclusive, no addition to it or declaration of the caste, tribe or subcaste parts of the group, tribes or tribal communities is permissible. My lord, I don't disagree to that it cannot be included. But question is whether the courts, all the courts below, including the person who heard the application under section 22, equated me that whether my caste is included in this list or not has not been taken into consideration. This is my only point. I don't say that that can be an intrusion. Obviously, it cannot be.
No, for each state, they've already got a list of scheduled castes.
Yes. My caste, I am admittedly scheduled caste in the state of Bihar. That is not in.
We're not about Orissa.
Yes. Whether my caste is included in the state of Orissa or not was to be considered.
No, there is a list. So if
yes,
your caste
that
is there,
list
it should already be there.
That list was never taken into consideration. That is my
point. Where is that list? Is your caste figuring in that list?
My lord, that list is most probably, my lord.
No, how do you then argue that it was never considered unless you have seen the list and you know whether your caste is there?
I filed that document before the honorable single judge.
No. What is they say in the counter affidavit? Let's see the counter affidavit, sir. We'll know that. Let's see the counter affidavit.
State has not filed any reply. This was filed by the private opposite party who had filed the application under section 22.
No. Assistant Collector Kionjar has filed, sir.
No, in this appeal, they have not filed.
In this appeal, we have filed.
Appeal copy has not been given.
There is a counter affidavit in writ appeal by the assistant collector.
But that copy has not been served on me. I have only got the counter affidavit by OP number 3. Private opposite party. 3 to 5.
It is a pure question of law. OLR Act is a state act and the benefits, a person who wants to derive benefit under the OLR Act, he is to be declared as a scheduled caste in the state of Orissa. That is the view of all the courts below. And he is not a declared scheduled caste so far as state of Orissa is concerned.
That's the point.
That is the only point.
If
all courts
they have given a counter, my lord, am I not entitled to a copy of the same?
Counter, this is what only we have.
At least I will see that stand, my lord.
Copy of the counter affidavit filed on behalf of opposite parties 1 and 2 be served on counsel of the appellant within 2 days. List on 28th September.
My lord.
My lord, there is another matter similar 2 to 3 of 2012. WA 2 to 3 of
list along with 2 to 3 of 2012 on that.
Yes, it is another. My lord.
Weekly list item number 4.
4 and 5. None appears with the appellant. This was not possible.
Weekly list item number 6.
So, Lord, since initially this repetition of the writ appeal was filed against the interim order. In the meantime, that has been merged with the final order. And the final order.
The appellant points out that the main writ petition has now been disposed of. What is that connected writ petition? 11677?
That is the writ petition. That has been decided already on 14/8/2012.
All right. Therefore, the writ appeal which was against the interim order, has been rendered infructuous. It is disposed of as such. WP Civil 11677. You see, there's already a final order. Need not be shown. All right.
Weekly list item number 7.
My lords, item number 7, 8, and 9 not placed.
counsel for the appellant states that he is not pressing these appeals. This post of not pressed.
Weekly item number 10,
None appears to is not pressed.
weekly list item number 11,
Item 10, my lord, I am appearing for the opposite.
Or no, item 11.
11 is opposite.
No.
Item 11,
Item 10, I am appearing for the opposite part.
item number 11,
May it please your lordship. Your lordship, I am the petitioner in the first matter. This is for implementation of an order of the Deputy Chief Labour Commissioner. Your lordship may have annexure 1 at page 20. Well, there is a connected matter where this order is under challenge also by the Paradip Port Trust.
Who's appearing for the Paradip Port Trust?
I am appearing.
So let's first hear your matter,
Yes,
then we can
yes,
talk of implementation.
Lordship, before Lordship presses, I press the Lordship on merits. The similar matter between the same petitioners involving the same plan for different years, of course, was pending before this Honourable Court, and Honourable Court has stayed the petition. If your Lordships hear that matter along with this, then
All right, where is that?
WPC number 1878 of 2022, your Lordship.
It's not listed today.
Not listed today, your Lordship.
All right, list along with 1878 of 2022.
Yes, your Lordship.
All right. On,
As your Lordship.
there's no date in that 22 matter.
It was no date. Only notice has been issued, and 24th August it was been list on 24th August.
No. Who's the bench which is?
The Honorable Justice Jaswant Singh, your Lordship.
You say list before that bench only. Then. Okay, list these two matters along with that before the bench of Justice Jaswant. All right. 24th.
Grateful.
Grateful.
weekly list item number 12,
Number
Your Lordship, item 12 may kindly passed over on behalf of Mr. P.K. Padi, your Lordship.
All right.
weekly list item number 13,
None appears dismissed in opposition.
weekly list item number 14,
14, no instruction.
No instructions disposed of.
weekly list item number 15,
None appears dismissed in opposition.
weekly list item number 16,
15, with leave of your lordship, I humbly submit, my lords. The petitioner seeks appointment under rehabilitation assistance scheme.
There is single bench matter, madam.
My learned friend suggests that your lordship, this is a single bench matter.
Service matter.
All right. List before the learned single judge on 28 September.
If I beg your lordships, one line submission subject to your lordship's approval. May I beg your lordships only to prepone the date subject to your lordship's
So
approval?
this came up on its own. None of you mentioned it.
On 8/9/2011. That is at page 31, your lordship's 11, page 31. That is the paragraph 4. Learned counsel for the petitioner invited our attention to the proviso under section 20 of the RTI Act, which includes that the burden of proving that information officer acted reasonably and diligently shall be on the central public information officer or the state public information officer, as the case may be, has not been done. Therefore, imposition of penalty for 73 days of delay, 250 per day, which comes to 18,250, is not tenable. And the explanation offered by the petitioner with regard to delay in furnishing documents to the opposite party number 3 has not been properly considered. And the reason assigned at paragraph 8 of the impugned order by the Information Commission rejecting the application filed by petitioner is not correct. Accordingly, allow the writ petition, pass the impugned order, and remit back the matter to the opposite party number 1 to reconsider the matter and dispose of the same after giving an opportunity to the petitioner. Opposite party may file the written notes of submissions. Now, let's pursuant to that. Let's the proceeding start. May I take your lordships directly to page 34. Let me come to the page 37. Let's in page 37. There is annexure to the here what has happened, the entire Paradip Port Trust, when the act was under initial operation, one PIO was given. The entire Paradip Port Trust with 5,000 employees and 8 departments, and with all what happened thereafter, on coming to know, they changed 16 officers were appointed. By then, he was the secretary of the Paradip Port Trust. The applications was received and information was supplied. At page 37 that I have given, that 16 officers that the Paradip Port has appointed thereafter to deal with each department with 2 officers. My submission, Your Lordships, that this aspect, that this person was overburdened and that he was discharging 16 officers' work has not been considered, though it was filed with the Your Lordships, the 18 notes which was given, but the same was not considered. Plus, admittedly, there was a delay. There is in 71 days. Ultimately, it was. It has been
73 days.
If we read the Act at Section 20, there are 2. Section 20, Your Lordships, Right to Information Act 2005. There, where the Central Information Commission or the State Information Commission, as the case may be, at the time of deciding any complaint or appeal, is of the opinion the Central Public Information Officer or the State Public Information Officer, as the case may be, has, without any reasonable cause, refused to receive an application, information has not been furnished information within the time prescribed under Section 1 of Section 7, or malafidely denied them. That there was a reasonable cause that
what cause we given, sir. Let's come to para 10, page 42.
Para
10, page 42.
My lords. There it is said, my lords, that when the
You want
initial
to read it, sir?
my lords, it is seen from the chronology provided by the CPO delays in processing the application of RTA application dated 16/5/2008 occurred in 2 stages. First, CPO received the RTA application dated the same day, but he sought the assistance of the holders of the information only on 28/6/2008. That is after more than 1 month. Secondly, the CPO held on the information for more than 1 month. The holders of the information who were primarily responsible for providing information to the appellant to the CPIO acted with great promptness, but the same was sadly lacking in CPI's actions. CPI has not given any explanation regarding the delay in seeking assistance of the holders of the information. My explanation, which was given with that I shown to your lordship, page 37. The same ground that's not been taken up by not been answered before.
No, just come to para 12. The underlined portion, you seem to have underlined it already for us.
In the instant case, the CPA kept the RTA application with him for more than.
It is difficult, that underlined portion. Middle of that paragraph, sir.
Minutes. It is difficult to believe that CPA could make more than 1 month take more than 1 month simply in compilation and of the information received from the various holder of the information. I do not find any reason or justification in the submissions given by the CPA for delay in furnishing the reply to the complaint. It is seen that the total delay comes to 71 days. From the date of receipt of the application 16/5/2008 till CPA furnished a reply to the complaint on 25/8/2008. Therefore, a penalty of 17,750 for delay of 71 days at the rate of 250 per day is imposed on Sri Prabhat then CPA and the ex-secretary of the.
What is wrong with this?
My submission, your lordships, that I have only that para page 37. Plus, I was discharging 16 officers.
Still not explained why it took you 1 month to simply write and ask for this information.
The secretary.
And after they provided it, you again sat on it for a month.
My submissions before Lordship, secretary is the departmental head. At the office level, these are not. The act came in 2005. This order, this was in 2008. There was a situation then. In the meantime, 11 years he has retired from service.
Now he can easily afford to pay.
And
18,000 is nothing.
16
These days,
officers have been
18,000 is
appointed.
nothing, sir. You're repeating the same thing about 5,000 employees, 16. In fact, if it has diversified, then there should be no problem.
So they ultimately they understand they appointed 16 officers.
This is the fourth time you're saying this. You have no other argument, I think.
I'm not saying. I have no
Same thing, like a scratch record you're saying.
That is the ground, Milord. That is the ground. That is the ground. I have nothing
Counsel,
to.
you see, the challenge in the present petition is to an order dated 8th June 2012, passed by the Central Information Commission, bracket CIC. Whereby, after finding that the petitioner as the Central Public Information Officer, bracket CPIO, of the Paradip Road Trust, bracket PPT, had kept the RTI application with him first for 40 days without taking any action, and then after receiving the information, took 38 days to compile the information. And then the total number of days delay was 71 days. Imposed a penalty of rupees 17,750 at rupees 250 per day. Paragraph. This is the second round of litigation concerning the impugned order. No, concerning the issue. Full stop. In the first round, against an order dated 9th August 2011, the petitioner had filed writ petition civil. No, 31st August 2009. Against the initial order dated 31st August 2009 of the CIC, the petitioner had filed WP Civil 14551 of 2009 in this court. The said petition was disposed of on 9th August 2011. Noting the plea of the petitioner that his explanation had not been properly considered by the CIC. The said order dated 31st August 2009 was quashed. The matter was remitted to the CIC to reconsider the matter and dispose it off after giving an opportunity to the petitioner and opposite party number 3, that is PPT, to file the written notes. Paragraph. In the second round, the CIC has by the impugned order reiterated that the petitioner unreasonably delayed providing the information and imposed a penalty as indicated herein before. Paragraph. Mr. Nanda, learned counsel appearing for the petitioner, urges that PPT is a large organization having more than 5,000 employees. Full stop. His submission is that the plea of the petitioner that being the administrative head of the organization, it was not possible for him to have attended to the RTI request earlier than when he did, has not been taken into account by the CIC. Full stop. According to him, there are 8 departments, and at the time when the request was made, he was the only person dealing with all RTI requests. So only later on 10 September 2010, 8 CPIOs were appointed, and he was appointed as the appellate authority. Stop. He mentioned that the petitioner retired from service on 31st May 2011. Paragraph. The court notes that all the above submissions have in fact been recorded by the CIC in para 8 of the impugned order. Sorry, in para 8 of the impugned order. Full stop. It is not as if, therefore, the CIC did not take into account the above factors. Paragraph. The requirement is under section 7, bracket 1 of the RTI Act, is that the CPIO should, on receipt of request, open quotation, as expeditiously as possible, and in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed or reject the request for any of the reasons specified in sections 8 and 9, unquote. Under section 20, bracket 2, where the CICs of the view that the CPIO open quotation has without any reasonable cause and persistently failed to receive an application for information or has not furnished information within the time specified under subsection 1 of section 7, ... It shall recommend for disciplinary action against the CPIO or the SPIO as the case may be. The attempt by the petitioner, full stop, under section 7, bracket 1. No, you just not a 7.2. Under 7, bracket 1, where the CIC is the view that CPIO has, without any reasonable cause, not furnished the information within the time specified under subsection 1 of section 7, then the CIC open quotation shall impose a penalty of 250 rupees each day till the application is received or information is furnished. So, however, the total amount of such penalties shall not exceed 25,000 rupees, unquote. The attempt by the counsel of the petitioner is to show that the CPIO in the present case had not acted unreasonably. Full stop. However, the admitted factual position has been noted in para 12 of the impugned orders under reproduced para 12 paragraph. There is no valid explanation offered by the petitioner for the two-stage delay, that is, delay in seeking information from the information holder, and then after that was received promptly, again sitting on the information received and not disseminating it to the applicant. Full stop. The court is satisfied that the CIC has taken into account all the factors mentioned in the submissions of the petitioner, including the one made before this court. And the decision arrived at cannot be found to be erroneous, cannot be held to be erroneous. Full stop. Consequently, the court finds no merit in this petition. It is dismissed as such. The interim order is vacated.
Published. List item 21.
Evidence will never be noted in this case, man. For CIC, we are
All right.
May I please?
Yes,
Yes. This is the second round of litigation.
Yes.
And in the first round, the state government approached the award passed by the Industrial Tribunal in WPC number 4493 of 2005.
Right.
And that petition was allowed, remanding the matter to the tribunal with the observation that to decide the issue whether the management is an industry or not. Well, in fact, after remand, when you may kindly turn to page 25.
Yes.
Page 25, paragraph 7.
Yes.
Well, in fact, after remand, the management did not appear in spite of notice and did not adduce also evidence so far as industry is concerned.
Then
that is one part. The second part is the tribunal, while directing for reinstatement of the workman, held that there is non-compliance of section 25F of the IDA. And here may I place your lordship kindly section 25. Well, it is said that no workman employed in any industry who has been in continuous service for not less than 1 year. Section 25F.
Yes.
Conditions precedent to retrenchment of workmen. No workman employed in any industry who has been in continuous service for not less than 1 year under an employer shall be retained by that employer until the workman has been given 1 month notice in writing indicating the reasons for retrenchment. Now, your lordship can say this continuous service has been defined at section 25B. Definition of continuous service. For the purposes of this chapter, a workman shall be said to be in continuous service for a period if he is for that period in uninterrupted service, including service which may be interrupted on account of sickness or authorized leave or an accident or a strike, which is not illegal, or a lockout or a cessation of work which is not due to any fault on the part of the workman. 2. Where a workman is not in continuous service within the meaning of clause 1 for a period of 1 year or 6 months, it shall be deemed to be in continuous service under an employer. A. For a period of 1 year, if the workman during a period of 12 calendar months preceding the date with reference to which calculation is to be made has actually worked under the employer for not less than
days, sir. In
clause
your
2
case,
will be
240
applicable here.
days.
240 days in any other case.
Correct.
Now, your lordship kindly see, well, admittedly, he was engaged for the period from 15/6/1992 till 12/4/1993. And
More
that
than 240 days, sir.
and that breakup, your lordship may kindly see page 4, paragraph 6.
Yes.
And that was not a continuous service. Paragraph 6, bottom, your lordship can see internal page 4.
So this you have to prove before the tribunal, sir. You can't now just make it a stay averment here. This has to be proved before the tribunal. You don't need any evidence, then how will it be proved? The burden is on you to have produced these records.
Exactly.
You see, this is the second round of challenge by the petitioner management to an award dated. No, concerning the dispute referred to the Labour Code Bhubaneswar in the following terms, take from para 2, page 23. Initially, the Labour Code passed an award dated 31st March 2004 in ID case number 152 of 1995 in favor of the workmen. That full stop. That was challenged in this court by the management by filing writ petition civil 4490 of 2005. 93 of 2005, which was disposed of by this court by an order dated 10th May 2010. And the matter was remitted to the Labour Court for a fresh adjudication. Full stop. It was observed in the said order as under open quotation. The Labour Court is therefore directed to deal with the specific question as to whether the management of horticulturist Ekamra Kannan, Bhubaneswar, is an industry or not, and the parties are at liberty to adduce fresh evidence and order and above the materials over and above the materials already available on record. Full stop, unquote. It was further observed, open quotation, the Labour Court shall also consider the question raised by the learned counsel for the state that the dispute is not covered and the dispute or act on the other grounds also. Full stop, unquote. The matter then went back to the Labour Court. Full stop. At this stage, it will be noticed that the case of the workman is that he was employed under the management as an attendant in the pay scale of rupees 750 to 940 per month on an ad hoc basis, initially for 44 days. And then he resumed. And then his appointment was extended from time to time by series of appointment letters for 44 days each, with 1 day's artificial break. Full stop. When the pay of the workman was reduced from monthly salary to daily rated wages with effect from 24th March 1993, the workman nevertheless continued in employment. Full stop. According to him, while terminating his services with effect from 13th April 1993, the provisions of Section 25 capital F of the Industrial Disputes Act 1947 bracket ID Act had not been complied with. Paragraph. The Labour Code and the Impugned Award, fresh award, dated 20th October 2010, framed one issue, namely whether the termination of services by way of refusal of employment of the workman with effect from 13th April 1993 was justified. Full stop. In para 7 of the impugned award, it's noted that after receipt of the case record from this court, open quotation, the management did not turn up in spite of notice to him. Full stop, unquote. Well, this was in the earlier round, is it?
This is second round.
Second round. All
Second
right.
round. Page 25. Page 25.
Therefore, it is seen that despite an opportunity given to the management, it did not adduce any evidence in support of the plea that the horticulture department is not an industry. Full stop. It may be recalled that this was one of the questions that was required to be dealt with by the Labour Court. Paragraph. Nevertheless, following the decision of the Supreme Court, in 1978, 2 SEC. What is this? Banerjee case?
That is Bangalore water supply.
The Bangalore water supply case.
But it derived from the Banerjee and Chatterjee for 1963.
1978, 2 SEC 213. This question was answered in favor of the workman. Stop. Paragraph. Mr. Mudali, while not disputing that he could not possibly question the finding of the Labour Court on the issue of whether the horticulture department was industry, nevertheless sought to urge that the workman had not completed 240 days of continuous service in terms of Section 25 capital B of the ID Act, and therefore provisions of Section 25 capital F thereof were not attracted. We'll stop here again. The management has not actually led any evidence whatsoever, even in the first round, to show that the workman had not completed 240 days of continuous service. We'll stop. In the absence of any evidence in that regard by the management, it was not possible for the Labour Court to have come to a different conclusion as regards continuous working of the workman for more than 240 days in 12 calendar months preceding his termination. Paragraph. For the aforementioned reasons, the court is unable to find any error having been committed by the Labour Court in passing the impugned award. The interim petition, writ petition is dismissed. The interim order is vacated.
Okay. Weekly list item number 22.
None appears dismissed from prosecution.
Weekly list item 23.
None appears dismissed from prosecution.
Weekly list item number 24.
None appears dismissed from prosecution.
Weekly list item number 25.
None appears dismissed from prosecution.
Weekly list item number 26.
None appears dismissed from prosecution.
Weekly list item number 27.
None appears dismissed from prosecution.
Weekly list item number 28.
I don't know, 26. I want to do this matter. The liberty is always I will file a press. 26.
26.
In 26, we say counsel petitioner seeks leave to withdraw this petition. The memo is taken and record. Disposed of withdraw. All right.
Item 28.
None appears dismissed from prosecution.
Item number 29.
May I appeal, Your Lordship, my lord.
I am appearing on behalf of opposite party.
I'd like to take a lordship to running page 12 of the impugned order, paragraph 8, my lord. That is with regard to preliminary issue, my lord. Paragraph 8, I am placing, my lord. On perusal of the evidence adduced on behalf of the both parties, it appears that no such separate issue has been framed relating to the question of fairness of the domestic inquiry in the facts and circumstances of this case. On the above score, the witnesses examined on behalf of the management stated that due to negligence on the part of the workman, the accident took place, for which management suffered heavy financial loss, and a departmental proceeding was initiated after the explanation submitted by the workman. He further stated that the inquiry officer, after giving sufficient opportunities to the workman, closed the inquiry holding guilty of the charges. During cross-examination, he has stated that basing on the inquiry report, the final report was passed and he has admitted that he had no direct knowledge about the facts of the case and also could not able to say that if the workman was present during the spot inquiry by the technical officer. Almost to the same fact is the evidence of MW2, Sri Dilip Kumar Das. During cross-examination, the MW2 has stated that as per the official record, the affidavit evidence was prepared and he had no direct knowledge relating to the inquiry conducted by the inquiry officer. On perusal of the inquiry report under the cover at Exhibit K submitted by the inquiry officer, it appears that the management had examined only Surendra Kumar Hota, who was the spot occurrence witnesses to the accident, and basing upon his statement, the workman was found guilty. Except filing of the statements of the witnesses and the workman, the inquiry report remains silent about the date of posting of the inquiry by the inquiry officer, and there is no material on the record to suggest that the documents were furnished to the workman during the proceeding in the presence of the inquiry officer. There is also no material to suggest that the charges were read over and explained to the workman, nor any liberty was given to the workman for filing up any additional explanation. Law is well settled that an inquiry cannot be said to have been properly held where unless the employee proceed against has been informed clearly of the charges leveled against him. The witnesses were examined ordinarily in the presence of the employee. In respect of the charges, the employee is given a fair and opportunity to cross-examine the witnesses. He is given a fair opportunity to examine the witnesses, including himself. He is in his defense, if he so wishes, on any relevant matters. The inquiry officer records his findings with reasons for the same of his report. On perusal of the case record and the inquiry report submitted by the inquiry officer, and after going through the evidence on both the parties, the procedure adopted by the inquiry officer appears to be not fair and proper, and the inquiry officer has not adopted the principle of natural justice while conducting the inquiry. This is the finding with regard to fairness of the domestic inquiry. So admittedly, though preliminary issue has been framed on this question, whether the domestic inquiry fair or not, and these the guidelines that they have quoted, my lord, these are the guidelines are quoted from the CCA rules meant for the government employees. But so far the industrial employees is concerned, that is the only principle is to follow, that is the principle of natural justice. But these are the guidelines as provided in CCA rules for government employees. But thus quoting these guidelines, they said that the inquiry is not fair and proper. But admittedly, the workman present due to domestic incident all through. He was also after
there's nothing to
order
show.
of punishment. He was
You've not
giving
even
the second
shown a
focus notice.
1 minute, sir. You've not even shown a record of when the hearings took place in the inquiry. Did you produce the record of inquiry?
Yes, my lord.
Where is it?
That is before the labor court, my lord.
No, where is it? In fact, the labor court, don't simply say it is before the labor court. The labor court says that you did not even show whether the inquiry was held, what dates it was held.
These are the procedures that have been quoted, my lord.
Sir, where is the record of inquiry? Please listen to the question.
Natural justice.
Sir, please listen to the question. Where is the record of inquiry?
That is before the labor court that has.
It is not there, sir. You have to answer this properly. Come to page 5, internal page 5 of the award.
Yes, madam. Page 5 minus.
Page, internal page 5, 6.
On perusal evidence adduced on behalf of the both parties, it appears that no such separate issue has been framed. It is the labor court is duty bound to frame a preliminary issue.
Sir, you have to produce evidence. You have not produced any evidence. Please come to internal page 6. Except filing statement of the witness of the workman. Just read that 5 lines from the top.
The witnesses examined on behalf of the management stated that due to.
Sir, internal page 6 of the award.
6 of that, yes, ma'am.
5 lines from the top. The sentence begins except filing.
Except filing of the statements of witnesses and the workmen. The inquiry report remains silent about the date of posting. Then the
Read the whole sentence, sir. Kindly do me a favor. Please read the whole sentence.
Yes, madam. Except filing of the statements of witnesses and the workmen, the inquiry report remains silent about the date of posting of the inquiry by the inquiry officer, and there is no material on record to suggest that the documents were furnished to the workmen during the proceeding in presence of the inquiry officer. There is also no material to suggest that the charges were read over and explained to the workman, nor any liberty was given to the workman for filing an additional explanation.
What is your answer to this? In your writ petition, what is your answer to this, sir?
Well, my answer is that
not like this. In your writ petition, where have you said that you produced the entire record of the inquiry? You told him about the dates of inquiry. Where have you said in your writ petition? Where have you challenged this finding in your writ petition saying the entire inquiry record is produced? Where have you said this?
Well, entire record, that is Exhibit K.
Sir, where have you...
From the record, it has been quoted.
Sir, from your writ petition, where is the averment in your writ petition that the entire record is produced? And that it showed that the workman has been furnished the documents, the workman was given a chance to rebut. Where have you said all that?
In the counter, the workman has admitted.
Sir, please follow the question in your writ petition. Where have you averred that the entire record was produced and the record showed the dates of inquiry, that the workman was furnished with the documents, that he was given an opportunity to make his defense? Where have you said all this? This is all mechanically drafted, sir. Nothing. Factually, you have nothing to show. If you're attacking under 227 an award of the labor code, you must be able to produce a record. You've not done that.
Paragraph F, ground number F, page 5 of my writ.
Yes, what have you said?
For that, the learned court below, on wrong conception and improper assessment of the inquiry, filed his observation that inquiry has not been conducted in proper procedure. The reason given by the learned court below that the charges were not read over and the explanation to the workman by the inquiry officer and the date of proceeding has not been mentioned cannot be treated as final and conclusive.
What is this? What is the meaning? What is the meaning of this? Cannot be treated as final conclusive. You don't show a record to the labor court. Why should it hold otherwise, sir? You have to show the record.
Entire inquiry.
So you have to show the record to the labor court and point out from the record, sir, this is how we have read over and explained to the workman. This is the date of the inquiry. On this date, we read over and explained. This is how you should show it.
That I am submitting, my lord. That is read over the procedure that has been quoted. that is meant for in the CC rules.
No, even that you have not said even that you have not pleaded here in ground F.
But that
Even in ground F, you do not say this is not a rule that applies to us. It applies only to some civil services. You have not urged that in their grounds.
Well, I will cite one decision, my lord, of the Supreme Court, my lord, kindly have a glance to this. That is reported in (2018) Volume 4, SCC 483. Kindly turn to paragraph 16.
So this is settled law, but preliminary issue. Here you have no evidence. You have to show that you have this additional evidence to show that the termination was lawful. You have not made that effort, sir. Even if we send it back to the labor court, you have no evidence to lead.
This procedure that
this can't be an empty formality. This is not an empty formality. You must show that you have material.
I have to substantiate of hearing. I have given him so called notice. Only principle on natural justice I have followed. But these guidelines that has been quoted, that is not for the
that is not your ground, sir. That is not your ground here. In all your grounds A to H, you have not taken that as a ground.
Those are grants, these are meant for for government employees.
So you have not urged this as a ground in your petition.
That is
nowhere in any of the grounds you say that.
Madam, can I have a glance to paragraph 17 of this judgment, madam? Paragraph 17 of this judgment. Just I will place the paragraph 17, madam. When we examine the facts of this case in the light of the aforementioned principles of law, we find that the termination of the respondent was by you a punishment because it was based on the adverse finding recorded against the respondent in the domestic inquiry. So the question which the lower court was expected to decide in this first instance as a preliminary issue was whether the domestic inquiry held by the appellant employer was legal and fair. In other words, the question to be decided by the lower court was whether the domestic inquiry held by the appellant was conducted following the principle of natural justice and or not. That is only principle of natural justice to follow.
Yes.
If the domestic inquiry was held legal and proper, then the next question which arose for consideration was whether the punishment imposed on the respondent dealing.
So you have to show that by not giving you a separate opportunity to lead evidence on the merits, you are unable to therefore place the materials which you have with you to show that the termination was fair.
The preliminary issue has not yet been framed at all.
So you have to show in a writ petition, you have to show what is the evidence you have. You have nothing to show.
Directly on taking recording the evidence, my lord.
All right.
No preliminary issue has been framed.
All right.
In paragraph 20 also that has been stated that
right.
We are constrained to observe that the labor commissioner committed an error in not framing the preliminary issue.
Yes.
They have to frame a preliminary issue. In paragraph 20, that has been quoted, my lord.
What is your age, sir? You are appearing for the driver.
Now he has been superintendent in 2009.
So now today, how old is he?
He is now 73 or 74 years.
So if your learned colleague succeeds, till he dies, nothing will happen because this will go back to the labor court.
My lord,
he will lead evidence for the next 5 years.
My lord,
good plan, sir. Very good plan. Keep this pending for 12 years, 13 years.
My lord, also they have not also complied the order of the subsistence allowance was not provided during suspension as well as when the till the compulsory retirement. That order also not being challenged by them. I am providing the same thing before your honor.
Master, my lord, direction I have deposited the entire amount before you.
No, my lord. But I am providing the same thing. Kindly have glanced to this order.
Have you deposited this entire amount, sir?
Yes, my lord.
But
I have deposited.
That should be made over to him.
But that also, I am of opinion that is disputed amount. That I am.
Whatever, sir. Let this amount be released to you at least.
My lord, you. This order also not being complied. We have filed a miscase before the under section 33C2. That is around for 80,000 and with 10% interest. which is awarded on 17th August 2012.
All right. You say on 5th October 2021, the following order was passed by this court. Reproduce the order. Pursuant thereto, the petitioner management has deposited a sum of rupees 1,93,224 in this court. Full stop.
I will kindly have glance to these calculations.
It may be mentioned at the outset that according to the workman, the amount due is much more. And he has submitted a calculation sheet in that regard. Full stop. In other words, according to the workman, no, even subsistence allowance was not paid during the time when inquiry was proceeding against him. In this regard, he had filed industrial dispute miss case number 97 of 2002 under section 33 capital C bracket 2 of the Industrial Disputes Act 1947 bracket ID Act for computation of his arrears wages from 1st March 1998 to 31st May 2001, including the subsistence allowance amounting to rupees 90,855. Full stop. He has placed before the court an order dated 17th August 2012, passed by the Labour Court in the aforementioned industrial dispute miss case number 97 of 2002, directing the management to pay him rupees 8864 within a period of 2 months, failing which interest at 10% thereon per annum would be paid till realization. So after accounting for all of the aforementioned sums, according to the workman, a total of rupees 611,326 is owing to him. Paragraph. The background facts are that the petition number one, that the workman was working as a driver with the OSRTC since 4th April 1976. Stop. An accident took place involving the bus which he was driving on 28th August 1999, which resulted in loss of lives and damage to the bus. Full stop. The driver was placed under suspension from 31st August 1999. At the end of the inquiry, the workman was compulsorily retired with effect from 31st May 2001. Full stop. The following dispute was referred to the Labour Court for adjudication. Take from page 8, paragraph. The workman examined himself as WW1 and filed 30 documents. To stop, the management examined 2 witnesses, Dilip Kumar Das, junior clerk, bracket MW1, and Ramesh Kumar Chotrai, DTM, bracket A, as MW1, and Dilip Kumar Das, junior clerk, as MW2. Full stop. Exhibits A to R and R/1 were exhibited by the management, approved by the management. On the issue of fairness of the domestic inquiry, the Labour Court came to the conclusion that the procedure adopted by the inquiry officer was not fair and proper, and that the inquiry was in violation of principles of natural justice. Full stop. On this aspect, learned counsel for the management sought to contend that the rule referred to in the impugn award pertained to inquiries in the case of government servants and was not applicable to the OSRTC. Full stop. The court finds that no such plea has been raised in the present petition anywhere. Full stop. In any event, on perusal of the award, what appears to have weighed with the Labour Court was not the aforementioned rule, CCS bracket CCA rule, as contended by the counsel for the management, but the findings on perusal of the case record and inquiry report. We'll stop. The specific finding of the Labour Court in this regard read as under. Take from bottom of page 6 on perusal of the case record and inquiry report. Unquote. Full stop. In fact, the Labour Court noted that, open quotation, except filing of the statement of witness and workman, that is page 6, 5 lines from the top, up to additional explanation, unquote. Paragraph. With the above findings being factual, the court finds no error having been committed by the Labour Court in coming to the above conclusion. Paragraph. Learned counsel for the management then relied on the decision Kurukshetra University of Prithvi Singh, 2018 4 ACC 483, to urge that once the question whether a domestic inquiry was fair was decided as a preliminary issue, the management ought to have been given an opportunity to lead evidence on the question of the legality of the order of termination by way of compulsory retirement. Paragraph. It appears that the management, even in the present petition, has not referred to any such document or evidence it would have liked to placed before the labor court in order to show that the termination by way of compulsory retirement was justified. Full stop. What is filed before this court is just a petition without any reference to any documents or record available with the management. Full stop. The demand for leading additional evidence on the merits of the termination order is not a mechanical one, cannot be an empty formality. Full stop. The management has to show what is the evidence it has in its possession, which it was prevented from placing for the local court, and as a result of which prejudice has been caused to it by not being able to defend the order of termination. Full stop. There is no such averment in the petition, and there is none of the documents or evidence that the management would like to rely on are even referred to in the petition paragraph. That apart, the court finds that the workman today is over 73 years old, having superannuated way back in 2009. Full stop. It would not be fair or justified to remand the matter to the labor court at this stage, with no hope of justice being provided to him. Full stop. As already noted, despite a stay order, the management did not care to implement the impune award during the long pendency of nearly 9 years of the present petition. Stop. It is only after this court passed the order on the previous occasion that the amount has been deposited in court. Full stop. Even this, according to the workman, is not the entire amount. Full stop. In all probability, he'll have to go back to the labor court to claim the balance amount. Full stop. For him, it is an endless struggle. Full stop. Paragraph. Consequently, this court is not persuaded by the arguments of learned counsel of the management that the impune award should be interfered with. Paragraph. The petition is accordingly dismissed. The amount deposited by the management in the court will be released forthwith to the workman upon proper identification by the registry within a period of 2 weeks from today. The petition is accordingly dismissed. No order is to cause.
Greatly obliged.
Weekly list item number 30. Item 30.
None appears dismissed on prosecution.
Weekly list item number 31.
31, my lords, I am appearing for Bhubaneswar Municipal Corporation opposite Patna 3. Lead petition
Who's for the petitioner, sir? 1 minute, sir. Who's for the petitioner?
I am for the petitioner, my lord. My lord, here the petitioner is a widow lady. Challenges the notice issued by the
petition has become infructuous. We have already relocated the sub room of the petitioner in a smart city project, and she is continuing.
Oh, all right.
So in view of this,
Bhubaneswar Municipal Corporation informs the court that during the pendency of the present petition, the petitioner has already been relocated under the smart city project, and she's already functioning from the relocated place. In that view of the matter, no further directions are called for the petitions disposed. All right.
Weekly list item 32.
Permitted to withdraw, my lord. Counsel, the petitioner seeks leave to withdraw this petition. Dismissed as withdrawn.
Weekly list item 33.
I am for the opposite.
None appears dismissed on prosecution.
I am for the opposite number 2, your lordship.
All right.
Weekly list item 34.
None appears dismissed on prosecution.
Weekly list item number 35.
35, my lord, infructuous.
Counsel, the petitioner states the petition has been rendered infructuous. This is disposed of as such.
Item 36.
No instruction.
No instructions disposed of.
Weekly list item 37.
None appears.
37, my pleasure, lordship.
Yes.
But I may be allowed to place the dead chart.
Yes, yes.
Copy table. But the petitioner challenge the order dated 5/8/2013 and 8/8/2013 by the Annexure 3 in directing the petitioner to pay premium at the current market in respect to land leased earlier in the year 1979. Well, in 1968, the petitioner's father being
Say,
a
did you
landless.
comply with the order dated 12/12/2013?
I could not deposit the amount. Therefore, I filed an application for extension of time, modification of that order.
Then what happened?
Well, that I will comply within 7 days. Your Lordship.
No. It's a 12/12/2013 order, sir.
My lord, I could not deposit. Thereafter, I filed an application for modification.
No. Nothing happened in that application, correct?
No.
So this, since you did not deposit the amount, this order has not been passed. That is to hand over possession to you.
Yes.
So the possession is with whom now? Who's in possession now?
Possession petitioner is in possession.
How can it be, sir? Just read the order dated 12/12/2013.
Yes, my lord. My lord, that order was to deposit the.
No, it is not only that. Just read that order.
Yes, my lord. Well, as an interim measure, it is directed that the Tahsildar Fulbani Kandhamal shall execute the lease deed and hand over possession of the land in question to the petitioner in terms of the direction dated 5/8/2013 issued by the Collector Kandhamal Fulbani, passed in ULSC number 187 of 1968, subject to the premium demanded by the collector is deposited by the petitioner before the registry of this court within a period of 2 weeks.
Stop
from
here.
today. Yes.
So first you had to deposit in the registry of this court.
Yes.
Thereafter, the Tahsildar would have handed over possession to you.
Lease deed is to be executed and possession was to be handed over.
Since you did not deposit the premium,
my lord,
possession was not handed over to you.
Yes, my lord. In fact, my lord, officially possession has not been handed over.
But now
yes.
the truth is coming out of the. So you have merrily encroached on some land. You're sitting on it without complying with the order of the court, and now you're saying you're continuing possession.
I would like to pray your lordship to kindly have a glance over.
And the state will not come to this court to say he is illegally occupying the land. They are also very helpful to you.
We have not handed over possession.
No, but you are very helpful. You're not asking him not to give back possession also. He has not deposited this premium.
Your lordship may kindly have order dated 8/1/2014.
The order of modification, my lord. Yes.
Nor shall be handed over to any other party, which means the Tahsildar was supposed to keep possession. That's what it means, sir.
Well, in fact, on prior 2 occasions.
What this order means is that you had better keep the possession with you. Don't hand it over to any other party.
Yes.
Now he is already occupying it. Without paying a single naya paisa, he is happily occupying it.
Well, in fact, in 1987, the lease deed was executed. They could
so
not.
You are not at all, you're missing the point completely.
My lord, I could follow your lordship, my lord. The petitioner is in, my lord, assuming the petitioner is in encroachment. Now, petitioner can be considered as an encroacher.
So you have not complied with the order. Why should we even hear you?
My lord,
you tried to modify it. We did not. We only permitted you not to pay the premium, but we didn't put you in possession. In fact, we told the Tahsildar, make sure nobody else also gets it.
Well, because of the financial condition at that point of time.
Sir, so you have merely, because of poor financial condition, you can encroach on any land. That is what we are trying to tell us.
Now, Millet, on earlier 2 occasions, the land was demarcated for giving possession to the present petitioner. But that
where is this land, sir?
Yes.
Where is this land?
Millet at Kandhamal.
What is its value, sir? Present market value?
That premium amount is also now must have been enhanced.
0.05 cents. And what are you supposed to pay? Sir, in terms of this, what are you supposed to pay for that premium? What is the premium you're supposed to pay?
Millet, premium was demanded 1,79,685.
What is today's market value? What is the market value today, sir, of this 0.5 cents?
So benchmark valuation,
Nothing. It must be much higher.
that I have to take instruction.
In
my lord.
2013, no. Anybody will tell you, sir.
The government has-
1,79,000 today, it must be 10 lakhs at least. For nothing, you're going to get, sir, land worth 10 lakhs. Even if you pay 2 lakhs, you're going to get land worth 10 lakhs.
My lord, in 75 deposit was made.
And you're merrily sitting on the land. Your friends in the Tahsildar's office are very happy.
My lord, I really,
There is an order of
my
this
lord,
honorable court
my lord,
not-
at my instance, the writ application has been listed, my lord. My lord, on several occasions, my lord, I pursued the matter for listing. The government has not filed the counter. My lord, I am in a hurry to for disposal of the matter and allotment of the land because I am not able to utilize. Although, my lord, I am in occupation, I am only, my lord, protecting the land from encroachment.
Very good, sir. You're doing a noble service.
Well,
You
yes,
want a reward for that.
How can you
Well,
say that you
You want an award for that, sir?
I have not
You're
made any
protecting
construction.
government land.
But I have not constructed. I have not constructed over that land.
Very good, sir.
Well, only I have kept in one enclosure so that it
Alright.
cannot be further.
So now you
enclosed.
have money for construction.
But I can deposit. I will deposit the money.
So we'll simply dismiss the writ petition, then you'll automatically have to deposit it. Your only challenge is that you can't pay the premium. Now you're in the position to even construct. So clearly you can pay the premium.
The construction.
What is 1,79,000, sir, for 0.5 cents in Kandhamal?
Well, it was in 2013.
Today we're 2022.
Yes, I will deposit.
So then withdraw this writ petition. As simple, just withdraw.
I will comply the order.
Just withdraw this writ petition then. You say counsel, the petitioner states that the petitioner is now in a position to pay the premium amount and he's ready to deposit it straight away with the government. Stop. In that view of the matter, he seeks leave to withdraw.
My lord, we have stated in our counter affidavit that we are giving him an alternative side.
The counter
and
has
we are
not been filed.
We are
They have not
yes, I have filed the counter.
No, they have not served a copy
we
of the
don't
counter.
want to give this land to him. So your lordship may not express.
No, we have not said anything, sir. He's withdrawing this writ petition.
Well, 79, the lease deed was executed.
All right.
Now they
Without
can
expressing any view on the above submission, the court permits the petition to be withdrawn. It is disposed of as such.
My lord may
The
observe
interim
that-
order is vacated.
My lord may observe that this court is not giving any observations
Well,
so
that
far as
is-
the
that
claim
is
of the
already the-
petitioner is concerned.
Yeah, we've said
Alright.
not without expressing any view on the claim of the petitioner. The petition is disposed of, is withdrawn. The interim order is vacated.
But with liberty to pursue the matter before the authority, my lord.
So that who's giving
That
you?
is-
Well, because I
Who's
will,
prevented you, sir?
well,
Nobody's
I will
prevented you.
deposit the premium. I will deposit. Well, now they cannot turn back in 1975. The land was leased out.
All right.
Well, I deposited in 1975, my lord.
When the possession is not handed over,
The
lease deed is
possession,
not
it is the-
executed.
Well,
How
it
can
is
you
the
say
duty
that
of the lessor. It is the duty of the lessor to hand over possession to the lessee.
lessor
They have
has
not handed
already
over.
changed?
Thereafter, my lord, even if,
Sir, this court's order was very clear. You just did not comply with it.
my lord, therefore I sought for modification and
Which was not agreed to, sir. Which was not agreed to because they only excused you from not paying premium.
My lord,
The court did not permit you to occupy that land. Yes.
Item 38.
well, I have not constructed over that land.
You have done a very noble thing, sir. Right.
Weekly list item 38. So item 38, we are space 15, my lord, kindly.
Item number 38, that is 18,000.
No. Dispute is, please kindly see, page 15. I have paid by your PDS, which I have claimed as refund. 18,000 refund was granted, but my claim was 2,62,000. So the dispute is 2,62,000, not 18,000. 18,000 not the demand. It's the refund, my lord.
I'm sorry, I'm on,
It's refund,
I'm
not
bad.
demand.
I'm on bad
Yes.
impression. Sir.
There's page 15. There's two questions are framed by your lordship. Three questions. Whether the work executed as per the work order issued by MCL means Bharat Coalfield Limited, is taxable under section 2G of the Orissa Sales Tax Act in absence of transfer of property and goods. Two, whether the London Tribunal is justified to discard the judgment of this honorable court in the case of Kandori Transport, terming the same as untenable without any deliberation in the appellate order. Whether the order passed by the tribunal is just and proper and can sustain in law.
No, but you were required to execute an agreement within 7 days of the receipt of the work order.
Yes, those are not the issues, my lord. Those have been done. Only here the question is, because if your lordship will say annexure 1, my lords, that is the genesis of the entire issue, my lords. But the work order, they have gone by the terminology, the wordings. hiring of suitable mechanical excavator for digging of overburden mechanically without blasting, removal of the same into tippers and mechanically transport of the same to specified dump yard at Chendipada area and exposing coal, same NIT, so and so. Letter of intent. Then description of work minutes. Hiring of suitable mechanical excavator for digging of overburden mechanically without blasting and removal of the same for tippers mechanically, also mechanically.
You say there's no transfer of property in the goods.
Exactly, Minos. That is my case, Minos. And quantity is Minos, such and such like cubic meter, and rate is also mentioned. This is Minos.
Let us see the judgment of the tribunal.
Tribunal, my lord. Yes.
Page 35.
It starts from Minos. Page 33.
Yes.
And the operative portion, my lords, may start from Millar's only the paragraph 5 at page 34, Millar's.
Yes.
The only point for consideration in this appeal is that whether the finding arrived at by the London SCST in confirming the assessment order passed by LO allowing 80% deduction towards labor and service charge is justified in the eye of law. Heard the London Council for the dealer as well as the London DCST appealed for the revenue and also gone through improved orders of both the lower forums. On going to the improved assessment order and order of first appealed forum, it is forthcoming that in one hand, the dealer claimed deduction of 100% towards labor and service charges. And on the other hand, the argument was advanced by the London Council for dealer is that the dealer should not be treated as a works contractor. But both the forums below have allowed 80% deduction on the gross receipt towards labor and service charges. Now, coming to the nature of work executed by the dealer, as per the work order, it is forthcoming that hiring of suitable mechanical excavators for digging of overburden, mechanical removal of the same to the tippers mechanically, and also mechanically transported to dump yard. Here, in this case, the contract is Mahanadi Coalfield Limited. Now, coming to definition, section of works contract under 2 JJ of the Waste Act includes any agreement for carrying out for cash, department, or other valuable consideration the building, the construction, manufacture, processing, fabrication, erection, installation, fitting out, improvement, modification, repair, commissioning of any movable or immovable property. The concept of works contract was decided dated by Honorable Apex Court in case of State of Madras versus Ghana Dunkel and Co. 85-9 STC 353 and also between the parties in 93-88 STC 124. Now, coming to definition of sale as per 2G means with all its grammatical variation, cognate expression in any transfer of property and goods for cash or deferred payment or other valuable consideration and includes 127 and section 2G3 speaks that delivery of goods on hire purchase or any system of payment by installments in a case of works contract, the sales tax pays when the hirer exercise option. There is a difference between contract for sale vis-a-vis works contract. In the famous case of Honorable Apex Union of India versus Central India, Machinery Manufacturing Co. reported in 40 STs 446. This is pre-84 43 amendment. The guidelines has been fixed. In the above reported cases, it has been vividly discussed as to what type of contract consisting of composite contract, the works contract and the
You must have some decisions yourself, right?
Sorry, man.
You must be relying on some decisions yourself.
Yes, Millards. One is, Millards, I have already annexed along with this STREV. That is Kandoi page. That is, Millards, at page 24. And that was not discussed and only said that this is not applicable. I will take your attention, Millards. Millards, paragraph 5, court has very vividly with the illustration as explained. Paragraph 5, Millards. Whereas the enlarged definition of sale pursuant to the amendment brought in by Constitutional 46 Amendment Act 8 to the Constitution of India 50 and consequent amendment in the Act includes transfer of right to use any goods for any purpose, whether or not for a specified period for cash, deferment, payment, or other valuable consideration. In order to decide whether a transaction to sell, the determinant factor is whether any transfer right to use involved. By illustration, we may indicate that if A allows his vehicle to be used by B for a consideration and the vehicle is placed at the control, custody, and possession of B, it may be a case of transfer right to use the vehicle for any purpose. Where, however, the control, custody, and possession over the vehicle remains with A, notwithstanding the fact that certain amounts are received as higher charges, no transfer of the right to use is involved. The intent of the parties, the mode of use, and several other surrounding and relative aspects have to be considered. A positive finding has to be given that there was transfer of the right to use any goods. In the instant case, we find that no such finding has been recorded by assessing officer. It was merely stated that petition number 1 received transportation charges vis-a-vis higher charges of the vehicles from MMTC. This, according to assessing officer, brought the said petitioner within the definition of dealer and the amount received were taxable. As indicated above, in the absence of any finding that there was any transfer of right to use any good, the question of petition number 1 being treated as a dealer doesn't arise. Transfer is one of the widest terms that can be used as per so transfer includes every transaction whereby a party divests himself or is divested of a portion of his interest, that portion subsequently vesting or being vested in another party. Transfer means passage of right from one to another. According to Morris Oxford Dictionary, it means convey to make over title, right title process by deed of legal process. The first meaning assigned to use is to employ for any purpose. A mere contract of hiring without more is a species of a contract of bailment. Whereas in Commission of Income of Bombay versus so-and-so, Anul Apex Court, the observations of Viscount Finlay in governance of the hospital Dublin versus Pullman, that the subject which is hired out is a complex one where applied. Right is a claim to a thing. It's a liberty of doing or possessing something consistently with law. A right is interest recognized and protected by law. Transfer of right implies that full liberty is vested on the transferee to have the right to use the goods at the exclusion of all others, including the owner of the goods. And on the basis of this analysis,
let's ask, yes, Mr.
Your Lordship, is but at page 36, Your Lordship, only dispute is whether the labor and service charges is to be allowed at the rate of 80% or 100%, Your Lordship.
So if there's no transfer of, because why is it 1800? Because you're presuming some element of transfer of property in goods.
Your Lordship.
Here there is no supply of anything, no sale of any goods, nothing.
Your Lordship. And also what page 23, the first appellate authority's finding is that the payment received also includes higher charges of machines and the sales tax collected at rupees so and so. So there must be, for that reason, so since all the details have not been produced, so for that reason, this finding has been arrived, Your Lordship.
That is different. The 12,000 collection is the bereft of this transaction. That is nothing.
What?
That doesn't arise out of this. 12,000 is different.
How can it be when there is a tax collection? When there is a tax collection,
let us see the assessment order. Your Lordship, kindly see the assessment order. No, that has nothing to do.
So, Your Lordship, there must be some element.
No element. No element. The order of assessment is very clear on this. Annexure 2. What has
conduit transport so far the conduit transport case is that whether there is right to use Your Lordship.
The whole difficulty
that decision is there.
In order that something
but
is
it
to
is
be brought
factual aspect, Your Lordship.
In order that any transaction is to be brought within the purview of taxation, it must be falling under 2G. 2G not only sells simplicity,
and that's a finding of the transfer of property in goods.
Exactly, and the assessing officer treats it to worse contract. Plus 80% he has deducted. I say that 100% because there is no element of transfer of property in goods involved, either in same or any other form, as per 43 amendment. And then tribunal for the first time brings into this hiring concept. And hiring is totally out of place. There must be two parties and one must give the thing on fire. So that only when the last payment is made, then option. As Your Lordship finds a work order, there is no such element of hiring, even though the nomenclature begins with hiring, but essentially the work order doesn't involve any element of hiring minors. It's a mere transportation, excavation of that's overburden and transportation from one point to the other. That's all minors. This is the work. No involvement of sale at all. 2G doesn't attract. That is how minors the entire case. And 2G also dealt in by this honorable court in contrary case. That mere hiring nomenclature will not help. Mere that word that nothing will do unless something is brought into record to establish that there has been sale, either deemed or simplicity or whatever, but no sale of goods in any form. Either mirrors as works contract being deemed sales, nor mirrors any simplicity or buyer-seller relationship. Nothing mirrors. And mirrors, one judgment I am giving to Lordship mirrors that this overburden removal in the mines area is considered a service mirrors under Service Tax Law, Finance Act, under section 65, 67 mirrors. And this is considered a service mirrors. If my Lords may kindly see, of course, this is tribunal judgment. Against this mirror, I have given a page containing judicial analysis. All tribunals across the country are accepted, and Honorable Supreme Court has dismissed the appeal of the department, of course, on the ground of monetary limit. But this is how the matter is dealt in here.
Let me one more aspect. in your favor. Your Lordship, enter record and all those orders clearly says if all the orders have been perused, no material have been verified. Even the books have not been verified, whether the internal labor charges or not. Nothing has been verified. Your Lordship can verify that we go through the assessment order. As well as first appeal order, all are Your Lordship on flimsy ground that this has been done.
Then all the more, sir.
Your Lordship.
You say admit the following question of law is framed for consideration. You say this is a revision petition by the SSC arising out of an order dated 14th September 2012 passed by the Orissa Sales Tax Tribunal, Cuttack Bracket Tribunal.
Your Lordship may not record my concession, Your Lordship, because prima facie on the face of record it says.
Dismissing the SSC's appeal SA number 1103 of 2007-08. Stopped by the impugned order. The tribunal affirmed the order of the Assistant Commissioner of Sales Tax bracket ACST, dismissing the SSC's appeal by an order dated 8 May 2007, which in turn confirmed an assessment order dated 27th February 2006 passed by the Sales Tax Officer bracket STO, Ward A, Jagat Singhpur Circle, Paradip. Full stop. Paragraph. The following question of law is framed for consideration. Take from page 15, question A, paragraph. The background facts are that the petitioner was awarded a work order dated 1st April 2003 by the Mahanadi Coalfields Limited, bracket MCL, under which MCL hired from the petitioner a mechanical excavator for digging of overburden mechanically without blasting, and removal of the tippers mechanically, and transporting the overburden to a specific dump yard. Full stop. For this, the SSC received a sum of rupees 131,16,345 from MCL. Full stop. Since the work did not involve any transfer of goods and was a pure activity of service, the petitioner did not pay sales tax thereon. Full stop. The MCL deducted a sum of rupees 262,327.89 while making payment to the petitioner. Stop. The petitioner, while producing the TDS certificate for the above sum, claimed the said payment of tax by way of claimed refund of the said amount. Full stop. Paragraph. While completing the assessment for the period 2003-4 by the order dated 27th February 2006, the STO allowed a sum of rupees 104,93,076, being 80% of the amount towards labor and service charges, by treating the balance to be taxable under the OST Act. Full stop. The STO then held rupees 18,656 to be refundable to the SSC, when in fact it had claimed refund of rupees 262,327.89. Paragraph. After the appeal filed against the above order was confirmed by the ACST by the order dated 8 May 2007, the SSC went before the tribunal with the aforementioned appeal, which has been dismissed by the impugned order. Full stop. This court has heard the submissions of Mr. Jagavant Sahu, learned senior counsel for the petitioner, and Mr. SSC, and Mr. Sunil Mishra, learned senior standing counsel for the department. Paragraph. Mr. Sahu relies on the decision of this court in Kandoi Transport versus Sales Tax Officer, Assessment Unit Barbell. (1.11) Orissa sales tax cases. What is the actual citation, sir?
This is perhaps there in the compendium of unreported cases. There is a book.
Bracket, you say judgment dated 4th December 1991 in OGC number 576 of 1988, where the contract involved work of transportation, loading, unloading, and stacking. Which the petitioner in that case undertook for MMTC. Full stop. The court there agreed with the SSC that the work did not involve any transfer of property and goods. Full stop. It is explained in para 5 of the said judgment. Para 5 and 6 of the said judgment is under. Take from page 26-27. Paragraph. Mr. Mishra and ASC, on the other hand, referred to a line in the order of the ACST that a sum of rupees 12,672 had been collected as sales tax, and therefore there ought to have been some transfer of property and goods or sale of goods for which the sales tax was collected. Paragraph. The court finds that neither in the order of the STO nor in the order of the ACST is it explained that there was actually any sale of goods involved in the execution of the...
Sorry for the interruption. At page 22, there is mention of that. Execution of and your kindly see 7-8 lines from the top, page 22. Rupees 1,05,000 from local people towards hiring their machinery.
Correct.
This is towards that.
No, I'll explain that.
My lord, sorry.
Any sale of goods or any transfer of property and goods during the execution of the work by the petitioner, by the SSC. On the other hand, Mr. Sahu has pointed out that in the order of the ACST, it has been noticed that the petitioner had received rupees 1,05,000 from local people towards hiring charges of machinery. And it is possible that the sales tax collected pertained to that amount.
But that is not in the finding. But that is whether that amount relates to that.
In any event, merely because a sum of rupees 12,562 has been shown as having been 672 has been shown as having collected a sales tax will not mean automatically that in execution of the works for the MCL, that is the use of the mechanical excavators for digging of overburden and removing it through tippers and transporting it to a dump yard, there was actually any transfer of property and goods from the petitioner to the MCL. In the absence of any specific finding in that regard by the STO, it could not have simply been presumed that 20% of that work is attributable to such sale, thereby limiting the deduction only to 80%. Full stop. In other words, the disallowance of 20% of the hiring charges has to be based on some material which is available to the STO or to the ACST. Full stop. On the other hand, the facts of the present case appear to be closely aligned with the facts in Kandoi Transport Supra. And there is nothing to show that the discharge of the work order by the petitioner involved any sale of goods or any transfer of property and goods from the petitioner to MCL. Paragraph. Consequently, the question is answered in the affirmative in favor of the SSC and against the department. And it is held that the entire sum received by the petitioner from MCL for performing the work order was not exigible to sales tax and the amount of TDS deducted by the MCL was refundable to the petitioner. Full stop. The impugned orders of the tribunal, the ACST and STO to the above extent are hereby set aside. The revision petition is disposed of.
List item number 39.
Your Lordship, item number 39, Your Lordship may kindly turn to page 10, the question of law.
What's the delay here?
Your Lordship, delay is, Your Lordship, 27 days. I'm sorry,
delay is condoned.
Your Lordship, the question of law is that the tribunal aid in interpreting the provision contained in Rule 33 of Orissa anti-tax rules and thereby committed grave error in law in interfering with the conclusion of the authorities below that the dealer having exercised option in Form E14 prescribed under Rule 33(1) of the Orissa anti-tax rule on dated 31st March 2004, the dealer is not entitled to claim benefit under the sub-rule for the assessment period 2003-4. Now, Your Lordship may kindly turn to the finding of the tribunal at page 18, paragraph 5, Your Lordship. Your Lordship, just below 2 lines, but after receipt of an objection report, AG, the learned STO reopened the case on the ground that option exercised under section 33 is not valid as it is filed on dated 31st March 2004. At the far end of the financial year and not at the time of filing of return, for which the dealer appellant is not eligible for concessional rate of tax at the rate of 1.5%, and tax is to be paid at the rate of 2%. Same was also confirmed by Learned First Appellate Authority. Learned ACST has mentioned that his appeal order that according to sub-rule 2 of Rule 33, Your Lordship may kindly turn to Rule 30.
That's there, sir. He's already quoted it.
No. That is sub-rule 3 he has quoted. Your Lordship, the sub-rule 2 or of Rule 33 option in form should have been exercised at the beginning of the financial year while filing his return, but the dealer has not filed his option in time. Hence, both these fora below have disallowed the concessional reserve. On the other hand, sub-rule 3 of Rule 33 provides that if the dealer exercising option under sub-rule 1 becomes ineligible for doing so, any time after furnishing the option, then the said option shall be deemed to have been withdrawn from the date of he become ineligible. But it is seen neither in the order of assessment nor in the appeal order, first appeal order, the dealer in question has been declared ineligible for late filing of option. So by cognizing Rule 33, sub-rule 3, the learning tribunal has allowed that since he has not been declared as ineligible, so it is eligible.
What was the last date for exercise of option? Is that something like that?
At the time of filing of return.
No.
Yeah.
Is there any rule which says it has to be at the time of filing of return?
33 sub-rule 2.
Let's see that.
of anti-tax. Your Lordship, it is pre-amended. I think that has been omitted. 33 in the next page. 33 subrule 2. Got it, Your Lordship? Your Lordship. The dealer exercising option under subrule 1 shall pay along with the returns under sales tax rule an amount for the period covered under the said return at the rate of 1% of the total purchase and 1.5% of total
This
purchase.
doesn't mean that if he exercises option at some other point, it will not be, he'll become ineligible. That's not what it says, sir.
Your Lordship.
It merely says dealer exercising option shall pay along with the returns.
Your Lordship.
It doesn't say the last date for filing, exercising option is the date of filing the return.
No, Your Lordship. At the filing of return, he has
this is not that mandatory nature, sir. This is not like if you do not exercise the option at that stage, you can never exercise it. It's not like that.
Your Lordship, it is the compounding tax liability. So he has to keep the option at the beginning of the year. That I'm in the specified form that I may be permitted to take compounding.
So there's nothing saying that he has to do it at that beginning.
At the time of filing of return.
If he exercises the option, he pays it with the return. That's not it.
At the time of filing of return.
It's a possible interpretation, sir. This is not so mandatory. The language is not as so mandatory that if he does not,
and the tribunal recognizing that subrule 3, that since he is not ineligible, hence eligible. So that quite absurd. Your Lordship, subrule 3. If the dealer exercises.
Anyway, that's not the point. Anyway, that's okay.
But Your Lordship 33(1). Notwithstanding anything, a dealer may submit his option E20, E14.
Anyway, this rule itself is gone, sir. It's only for 1 year. We need not be exercising our minds for that. The revenue is in appeal. This revenue has filed this revision petition questioning an order dated 28 July 2012 passed by the Orissa Sales Tax Tribunal. Cuttack Bench Cuttack, bracket Tribunal. Allowing the SSC's appeal, SA number 13, bracket ET of 2010-11. Thereby setting aside the order stated 22nd July 2009 of the ACST and the corresponding order of the sales tax officer, bracket STO, raising an extra demand of rupees 122,326 on the SSC for the year 2003-04. Paragraph.
Your Lordship, the question of law may be open. Let's see, let it be because 1,22,000. So let the question of
what leave it open, sir. This is over. No? The rule itself is revealed now.
Yeah, let's see.
The only ground on which the extra demand was raised was that the dealer had not filed an option under Rule 33 of the Orissa Entry Tax Rules, 1999, bracket OET rules. In Form E14 to pay in lieu of the tax payable under the rules an amount specified in Subrule 2, paragraph. The tribunal has noted that the dealer exercised the option not at the time of filing the returns, but on 31st March 2004. That is the last date before the close of the year in question. Stop. It was sought to be contended by the department that since the option was not exercised at the time of filing the return, the dealer was not eligible to concessional rate of tax at 1.5% and tax had to be paid at 2%. the tribunal, relying on the wording of Rule 33 bracket 3, came to the conclusion that the dealer, open quotation, need not be declared eligible to avail the concession, unquote. Paragraph. It may be noted at the outset that Rule 33 of the OET rules has itself now been omitted with effect from 28 February 2011. Full stop. It is not, therefore, not as if the impugn order of the tribunal will constitute a precedent for other cases after that date. Full stop. Nevertheless, it is seen that from the wording of Rule 33 bracket 2 of the OET rules, there is nothing to indicate that if the dealer did not exercise the option at the time of filing the return, he would be precluded from exercising such option at any time before the close of the year in question. Full stop. Rule 33 bracket 2 of the OET rules reads as under. Rule 33 reads as under. Just quote the whole of Rule 33. We'll just say A to A. It appears to the court that in the absence of any express words in Rule 33 bracket 2 which mandates the exercise of option only at the time of filing of the returns and at no other time, it's not possible to agree with the STO and ACST that failure by the assessee in the present case, to exercise the option under Rule 33 bracket 1 at the time of filing the return would preclude him from doing so at any later point before the end of the financial year, thus making him ineligible for the concessional rate of tax. Full stop. Consequently, no substantial question of law arises from the impugn order of the tribunal. The revision petition is discussed.
Weekly list item number 40.
Well, item 40, the officer reported for a delay of 47 days, but actually there is no delay. The order was received by us on 3.
All right.
My lord, kindly come to page 125. The Celtics Tribunal has remanded back the matter to the ACST for fresh hearing.
So what is wrong with that, sir?
And the impugn order has been set aside. No, my lord, there is no, nothing wrong in that. But my submission that I'll raise all my points before him. Let him decide within a time frame manner. He so far has not been heard.
So because you filed this, sir.
After this.
It is not open remand.
By the impugned order of the tribunal, the matter has simply been remanded to the sales tax officer for a fresh assessment. Full stop. With that view, the matter, the court does not persuaded to frame any question for consideration in this revision petition by the SSC. Full stop. The STO is now requested.
ACST matter. ACST.
ACST. The ACST now is requested to proceed in accordance with law pursuant to the remand order.
No,
and complete the proceedings within a period of 6 months from today.
Your Lordship, as per the remand order, because in the remand order, it has been observation in the earlier paragraphs. Basing on the observation in the
whatever, sir, we are not interfering.
Your Lordship.
I am a small player. But the display board we cannot see because of the distance. Can it be shifted somewhere? It's so far away that we're not able to read it.
We'll do that.
Okay.
We'll do that. Right.
Weekly list item 41.
May I please, my lords? The questions of law, my lord, is at page 6 of your lordships. And in my humble submission, my lords, questions B, C, and D will be relevant for your lordship's kind consideration. May I just place these 3 questions, my lords, at page 6.
Yes.
B is whether aluminium extrusion falls under entry 11 of part 1 of the schedule of the OET Act and is liable to entry tax at the rate of 1%.
Notice has already been issued or not yet?
I don't.
What's the tax effect here, sir?
The tax effect, my lord, is 4 lakhs, my lords. It's 4,45,696.
Yeah. The questions have already been framed, sir. Two questions have been framed.
No, it's
whether aluminum extraction falls under entry 11 and whether tribunal is justified in holding the penalty under 7.5.
I'll be only addressing your lordships on these two issues.
All right.
So far as aluminium extrusions are concerned, my lords, your lordship, I'd only humbly pray your lordship may take up the Entry Tax Act, Schedule 1, Part 1, lords. That your lordships will get it at page 74 if your lordships are holding this same Entry Tax Act.
Yes.
Entry 11, lordship got it?
Yes.
Entry 11 reads, my lords, sheets,
rods,
etc. of non-ferrous metal, including aluminium, my lords.
Right.
I deal with aluminium extrusion, my lords.
Right.
My humble contention, my lords, that your lordship knows that entry tax schedules, my lord, have asked for specific goods. And if those specific goods are not in the schedule, my lords, it's not liable for imposition of entry tax, my lords. And why I say so, my lords, if your lordship would kindly see entry 8, my lords. Gunny bags, your lordship got it, my lords?
Yes.
Gunny bags, jute twines, jute and jute products. So the legislature was aware of including every jute product, my lord, under entry 8, so as to make it liable for entry tax, my lords. Similarly, my lord, if your lordship would kindly turn to entry 16, 16, my lords. It's tobacco and tobacco products.
Your lordship has already decided that Kendu lips and BD.
Ticket.
Sir.
Tobacco and tobacco products, my lords. Then, even though, my lord, tobacco and tobacco products are there, my lords, still, if your lordship...
What are extrusions?
Lord, extrusion, my lord, is a process where aluminium is drawn out into certain angles and rods, my lord. If your lordship would see the hangers which are used for these false sealing purposes, those are the materials which was being sold by the petitioner, my lords.
So sheets, rods, etc. The word etc.
The word etc. in my humble submission,
Lord,
would qualify sheets and rods. So if it had been aluminium sheets or aluminium rods, subject to kind correction of your lordship, my lord, had it been aluminium sheet or rods, my lord?
No, then there will be no meaning for etc. then.
Etc. my lords, etc. would include, my lords, other goods relatable to sheets and rods, my lords, not extrusion, my lords. Extrusion, my lord, is a specialized mechanical process, my lord, where it is drawn out, my lord. If lordship would,
even a rod is drawn out only.
No, my lord, rods are, my lord, it's spun, my lord.
Sheets are drawn out.
Sheets are drawn out. And so far as extrusion is concerned, my lord, it's sort of a extracting from aluminium.
Let's see the dictionary meaning of extrusion.
No, extrusion, my lord, I have just found out, my lords, it's act of extruding or throwing out or expulsion, my lords. So if this aluminium is...
No. Extruding is a verb.
My lords.
Extrusion here is a noun.
My lord, extrusion, my lord, is the process.
Here it's a noun. Here it's a noun.
My lords. So extrusion, my lord, is drawing out of aluminium. So from aluminium ingots.
No, not the act of extrusion. See, aluminium extrusion here is
the product
is called aluminium.
The product is aluminium extrusion. So what I get, my lord, after the extrusion process.
How does it look? What is it?
Lord, it's like a, if your lordships, pardon me, my lords, those hangers which are used for these false ceilings, my lord. It's like a thin piece of hanger, my lord. It's a small angle.
So why can't it be equated to a rod or something?
No, rod, my lord, is something which is, my lord, so far as commercially much different from our angle, my lords. If your lordship would go, my lords, and use the common parlance test or the commercial test, my lord, angles, rods, and sheets.
No. So you want to say these extrusions are not amenable to tax at all?
My lords. My lords.
All right. You say since it's not mentioned as such in the schedule?
My lords. No, because why I say so, that's why, my lord, I was taking a lordship to entry 8, my lords. The legislative intent, my lords.
Yeah.
My lord, it says gunny bags, jute twines, jute and jute products. So it includes every product of jute, my lord.
Correct.
Then if your lordship would kindly take up entry 16, tobacco and tobacco products.
Correct.
Then your lordship would see, my lords, entry 26, paints, and varnishes of any form.
Correct. So what is, when you use the word etc. in a schedule like this, what would that mean?
No, etc. in my humble submission would qualify anything equivalent to a sheet and rod. Nothing beyond that, Lord.
No.
It's in an adjusted generous case, my lords, etc. would qualify sheets and rods. It can't be any other product of aluminium.
Is there a case law for that?
Has the word
there is no
etc. been used elsewhere? Even there is no full stop after etc.
No.
Yeah, let's see, seeds, rods, etc.
Let me complete my learned friend.
I think there are two etc's. It's in part 2. It's not in part 1, but still, just to understand. Part 2, entry 4, soft drinks, fruit juices, etc.
Soft drinks, etc. means anything akin to soft drinks, my lords. Now, supposing soft drinks, etc. means soft drink akin.
Next entry.
Sorry, my lords?
Next entry, 5.
Entry part 2, my lords?
Yes.
Part 2, my lords, cinematographic equipments.
Yes.
Including camera, projector, sound, recorders, etc. So anything
etc. would be any cinematographic.
My lords. It can't be anything else than this, my lords. So my humble
anything else. The question is an extrusion, anything else other than a sheet or a rod?
Anything else than a sheet. It can't be anything else than a sheet and a rod, my lords. So had it been aluminium sheet or aluminium rods, my lords, I bow down to your lordship's kind observation, my lords. But since extrusion, my lord, is completely foreign, my lords, to the schedule, it is not leviable, my lords. In my humble submission, then your lordship, I'll just take a lordship, lord. Having entered tobacco and tobacco products, my lords, why I say so, these are for specific goods. If your lordship would turn over the page, your lordship would get it entry 32. They again say pan masala and other tobacco products, including zarda. So having said tobacco and tobacco products, my lord, if it is an all-inclusive umbrella, my lord, for all tobacco products, the legislature in its wisdom would not have again said pan masala and other products, including zarda, my lords. So any specific goods which are not mentioned in the schedule, my lords, in my humble submission, my lord, will not be leviable to entry tax under Section 3, my lords, of the Entry Tax Act. So aluminium extrusion, having not been specifically included in the schedule, my lord, would not be amenable to.
There is no case law where etc. has been used.
I was searching for certain case laws, my lord. Unfortunately, because extrusion, your lordship would appreciate, my lord, are not akin to sheets and rods.
I don't know. We don't know that.
No. It's extrusion.
We don't know.
Not extrusion. Why is this, my lord? The word extrusion, my lord, is to draw out. If your lordship would permit me, I can refer.
How does this extrusion look? We don't even know that.
It's something like a flat piece, my lord. Extrusion.
No, can you get us photographs of it or something?
Lords, I'm sorry, lords, I've not got photographs. But that's why I gave you lordship.
Show us the product at least.
No, the product is something.
Just imagine it.
No, product is something like hangers used for the false ceiling, my lords. It's like a hanger, my lords. First, they give these hangers and they give this gypsum boards, my lords. Those hangers, my lord, are the aluminium extrusion products. Why say so, my lord? This is
aluminium extrusions.
One see.
No, aluminium. Extrusions. EX.
Can I?
No, sorry. What are you doing, sir? Extrusion. TRU. SI. First one. You have to, sir. Just turn it around to your screen. Just turn it around. This screen itself. Whatever you typed. Just show it to him. This screen must be having it. Are you able to see his screen? No.
I'm sorry, may I just go near?
You're not able to flip this like this, is it?
With lordship's kind permission, may I just?
May share the screen, man.
Oh, you can share. All right.
I'm grateful to my learned friend, Lord. She has taken out extrusion products and how they look like.
Yeah, we've also got it. I think it must be similar.
Same thing.
Can we share?
Same thing is on the screen.
Your Lordship may.
1 minute, 1 minute. I think you get the same thing.
Thank you. I'm holding the same. Methods. So these melods are neither sheets nor rods.
They're closer to rods.
But they're not specifically rods with great respect. Melods.
They're like
rods.
You're right. They're like angles.
They're like angles, melods. And with great respect, my lord, I have not brought a piece of to show it to your lordships. It's something like flat pieces which are suspended from the roof, my lord, to hold the false ceilings.
No, the only word, etc. Sheets, rods, etc.
Manage. Etc. My lord, with my humble submission, would qualify something akin to sheets and rods. It can't be extrusion products. And if your lordship would apply also the common parlance test or the trade test, my lords, there, my lord, aluminium extrusion products can never be sheets and rods.
Can I assist you? Let's say, etc. of non-ferrous metal, including aluminium. Off is there. Your lordship, there is no full stop. So this rod is also aluminium rod. Because why I'm saying so?
Aluminium rod. Aluminium rod, with great respect to my learned friend, aluminium rod cannot be aluminium extrusion.
Why I'm saying so, your lordship,
It can't be aluminium flats. Extrusion, my lord, is an aluminium flat, like structure, my lords.
You see this? Make it, just expand it. So there's an aluminum grill, flat.
Great respect, my lord. Aluminium extrusion is a process where aluminium alloy, my lord, is.
No, there are extruded products because here the way it is used here, it's a product.
My lord, sheets, my lord, is a product. Rods is a product, my lords.
No, even you're selling it. Look at your invoices. You'll be selling it as aluminum extrusion.
Right? Extrusion, my lord. My humble contention, my lord.
So you are using it as a product.
Thank you, my lord. I am using that as a product, but unfortunately, that word product is missing, my lords. That's why I had taken the lordships to entry.
No, these are extrusion products. All this entire thing that you're seeing on the screen.
Those are extrusion products. But with great respect, my lord, I have taken the lordship to entry 8, which says jute products. It doesn't say aluminium products, my lords. It doesn't say aluminium products with great respect, my lords. Unlike jute products, unlike tobacco products, or unlike varnishes in any form, my lords, it's not all-encompassing form, my lords. That's why I had taken the lordships to entry 8, my lords.
Etc. brings within its scope. That's how BD came within tobacco product.
Yeah, let's see, that is the intention of legislature because everything, why you're
Equating etc. with product. You're equating etc. with product. That's where the problem starts. If the legislative intent is not to equate etc. and products, because wherever they wanted to introduce products, they use the word product.
Well, because aluminium itself is a non-ferrous. Aluminium itself, why I have said at the beginning that it is not of iron, because iron there is another entry.
Okay, let's say that he's selling aluminium nuggets, pellets.
Your Lordship.
Will it be included in this?
That I have to examine.
No, just think of it. See, we have to logically, we have to make it to a logical end, right?
Your Lordship.
Aluminium pellets. It won't be included, you're clear?
Your Lordship.
So let's exclude things.
But Your Lordship, this interpretation.
Aluminium cubes, aluminium squares, aluminium cups. Let's say aluminium ware, tableware, aluminium tableware.
Yes, that is in iron.
No, not iron. Forget the metal is aluminium, please. Anything which is of aluminium, will you include it in this? That's the question. Aluminium cup is aluminium. Aluminium plate is aluminium. You will not, right? Because it's an identifiable product. This only talks of sheets and rods.
No, Your Lordship, that cannot be. Your Lordship, sheets and rods only, that cannot be restricted to these two goods only.
Why not?
My submission, Your Lordship. because it is wide enough. Because in so far, everything cannot, each and every entry cannot be put in the
they're
book.
supposed to. See, which is why they use the word. When the legislature wants to bring in a whole load of things, it uses the word products.
Your Lordship. Your Lordship is absolutely right, because in 1, 2 entries, there is product is there.
Because it's a taxing statute. Otherwise, we can just use anything. We can use purposive interpretation for other kind of statutes. Taxing statutes want to be
one thing. Your Lordship, my submission: aluminium sheet is taxable. Aluminium sheet is taxable.
Correct.
And the
clearly what you saw on the screen.
What is extrusion?
What you saw on the sheet. It's not sheet.
That not sheet. That extrusion is from the sheet. That's
another. It's a product.
That is a channel.
It may not be from the sheet. I'm sorry. See, they have molds. For instance, when they have that bracket and angle, they make a mold and the metal will be
channel. That is the channel.
The molten metal will be shaped to bring out this product. So it's not that the sheet has been beaten into something.
So it is just like aluminum channel.
Even if, let's say, cups are made from aluminum sheets, cups will not be included in this.
Let's see, that is aluminum channel. Shutter, etc.
These are clearly identifiable, distinct products. They are sold as such. Just see this. They're all distinct products.
Let's see. I think there is some. That interpretation is.
See, none of these contain sheets. It's very interesting. When we Googled saying aluminum extrusion as a product, it doesn't throw up a sheet or a rod. Just see that.
That absolutely.
Clearly, there are some shapes that you have, different shapes of aluminum product.
I leave it to Your Lordship, because it is Your Lordship.
Actually, it's very interesting. Aluminium is also used in aircraft. You can bring in a whole plane here.
Aluminium hinges are also there. Nuts and bolts are there.
You know, the aluminium body that aircraft have, once they sell the aircraft as scrap, once they decommission it, they make wonderful aluminium utensils from that. It becomes a different product. So, like aluminium utensils, for instance. It won't come here.
No, that must be a separate entry.
It comes from aluminum sheets, but it's
utensils is another entry is there. So far the utensils is there, that is another entry is there. So Your Lordship, but the interpretation is
Yeah. Correct. I think I'll do some more research. We'll reserve orders. Orders reserved. We'll just do some more research.
I leave it to your lordship's wisdom because your lordship here.
It's a transient one.
Your lordship.
There are always higher wisdoms.
So your lordship's wisdom is the highest for us in Orissa. So far as my penalty part of is concerned, your lordship may consider notes.
All right. Orders reserved. Yes.
We can list item 42. And in this case, questions framed is at page 16. Because even though the Learning Tribunal has set aside the matter, but the set aside order of the Learning Tribunal confines to only levy of penalty minors. So the penalty was levied under section 10, assessment was made under section 9C. So therefore, Learning Tribunal says there being nothing discussed, so therefore let it go. So on that, that is favorable. But so far as other two substantial issues are concerned, which survives Millers, the questions relate to that Millers, which is against me. Now, Millers, page 16, my lords may kindly see. And one question is already covered by your lordship's judgment. And the other issue is also covered by a bench of this honorable court, covered by Grace the Udyog of my lord's judgment. This honorable court.
Only two questions you raised. 9C.
Your lordship's judgment covers second question. Whether the submission of the audit visit report in form E27 suffer from limitation in view of provision of section 9B2 read with 11.5G. Your lordship said, if audit visit report is not submitted within the period of 7 days, which is provided under statute, and the word "shall" is there, it's a mandate that is to be.
The assessment, audit assessment is bad.
Not only your lordship said, if that is not complied with, all consequences cannot be sustained.
Correct.
Assessment, appeal, tribunal, everything your lordship cost.
All right.
And I will only refer to your lordship the dates
all right.
for this. And if on this I succeed, probably the other question needn't be answered.
Okay.
So therefore, I am addressing
the 9C question.
Exactly, Milords.
All right.
So first, I am addressing your lordship's Milords, item number 2, Milords.
Right.
Question number 2.
9B2.
For that, Milords, my lords may kindly see.
Your lordship, on this aspect, your lordship, I have to examine the record, your lordship. Why your lordship? Why your lordship? Because in some aspect, so far as the Jindal case also, your lordship, the audit visit report has to be submitted after completion of the AVA, not from the your lordship.
No, so the date stamp you want to see when it
your lordship, particularly whether on the date of submission.
Let me see the record.
Never mind, but everything is there here in the record. If I
don't have record. I'm always trying to be a fair counsel.
You are never on fair.
All right. Mr. Mishra states that he would like to see the original record for making submissions in this case. At his request, list on. When do you want it, sir?
Let's see. It is from
24th August. No, all right. 7th September. The record be kept ready for perusal by the court as well on the next.
All right.
Because I am sorry to point out, Milord. Interim order to continue, Milord.
Interim order to continue.
I'm sorry to say, Milord.
Yes.
Item 53, my name is not mentioned in the cause list. So that is how I could not be.
All right. The name of
item number 53, you have to argue 2J, na?
No, not 2J.
Then you'll.
I think
2J was
maybe his name we mentioned. All right. Right, sir.
My lord. Obliged.
Item number 43.
Item 43, your lordship, poultry amount.
Yeah, the amount being insubstantial. The questions of law, if left open, the petition is disposed of.
Item number 44.
Item number 44. There is dispute with the Orissa Anti-Tax Act. This order dated 6/7/2015 question has been framed. That order number 4. Whether under the facts and circumstances of the case, the tribunal is right to holding that penalty under section 10 of the OAT Act is chargeable when the dispute with regard to the levy of the tax on the goods in question is pending before the apex court and penalty is not mandatory.
How is this? Because if it may be pending before the apex court, but here once they found the evasion of tax, then they have to levy the penalty. Then as and when the Supreme Court decides against, the department, you can claim whatever.
No, my lord, this is with regard to entry, this has been already decided by the apex court with regard to the entry tax. So already
Your Lordship,
here that
Your Lordship, here what happened? Can I? Here what happened, Your Lordship? The petitioner has not paid the tax, has not admitted the tax by saying that the issue of levy of anti-tax, so far as that para 30 is pending before Supreme Court.
Right.
And Your Lordship might have remembered, I have already placed Honorable Supreme Court by interim order dated 10th February 2010, 3rd February 2010, directed the petitioners who are before Honorable Supreme Court that they will pay 1/3. And this interim order is only applicable to those petitions and petitioners who are pending before Honorable Supreme Court. In that order, and who are not pending, they can intervene before Honorable Supreme Court. The order was very clear, Honorable Supreme Court's interim order. And by cognizing that order, the petitioner has not admitted, has not paid tax, has not paid penalty. So for that reason, the assessment has been completed. And pursuant to assessment order, he has paid the tax. And now he is saying that penalty cannot be leviable since the issue was pending before Honorable Supreme Court. But Your Lordship, as regards to this, now in the meantime, Honorable Supreme Court has decided the matter on 28 March 2017, and it has been decided that levy is justified.
Correct.
But that penalty is justified, Your Lordship, since this penalty is
subject to the chance.
No, my lord, just have to draw your attention to the assessment order. This point never has been, what I have, with regard to apex court, they have not demanded the penalty. That the point is like that, this is covered by, my lord, NALCO judgment. That's section 10. Because question is, penalty is not mandatory. Because what happened in this case, the vigilance made the inquiry and submitted a report. And in the report, kindly have a glance to my lord, assessment order, page 9.
Yes.
Because here, in last 2 line, capital goods machinery value 49 lakhs, tax due not paid, and packing material 1/3 tax due not paid. So it has been reflected in the books of accounts. And in the next phase, in that is paragraph 2, in course of the examination of the books of accounts, the vigilance case report indicated above was discussed. It has been reported that the dealer has not paid the ET on the purchase of machinery and packing material over the 49 lakhs 685 and 138,467 respectively since 2006-7. On being asked to this point, the authorized advocate contended that due to judicial pronouncement of the Honorable High Court, the then enforced, the dealer did not pay the ET, but now he's agreed to pay the ET.
No, which is the year in question, sir? See, the period is 1/4/2006 to 30/11/2009, right? And which is the date of this order? 26/5/2010. So I'm presuming this happened sometime in 2010. All this interaction with the assessing officer.
Assessment order is, my lord, in 2010.
26th May.
My lord, that time.
So 10th March 2010 itself, all matters landed up to the Supreme Court.
My lord.
So you could not have still been under the impression that because of the High Court judgment, you don't have to pay. There are people already gone to the Supreme Court.
My lord, people has not gone to the Supreme Court. Department has gone to the Supreme Court.
Whatever, sir.
Both. Your Lordship, this Honorable High Court,
because High Court
in Reliance Industries case, has decided two parts. One part, this Honorable High Court has decided the Anti-Tax Act is to be intra-virus. Against that judgment, the petitioner has gone to Supreme Court. Many more than 300 SLPs are filed. And so at para 30 of that said judgment, in Reliance Industries judgment, this Honorable Court has decided that the anti-tax can be levied on the goods which are available within the state of Orissa. Anti-tax cannot be levied.
That is not in our dispute.
The goods which have been imported and not.
So only to that extent you went.
Yeah, only para 30 against para 30 state has gone to Supreme Court.
This contention that because of the High Court he does not have to pay was also not correct.
Not correct.
That contention not also accepted by the appellate authority. My contention, kindly have a glance to the first appellate order.
Anyway, it's not even an innocent contention, sir.
No, kindly have a glance to the first appellate order, that page 15. Kindly have a glance. The last paragraph.
Yes.
The contention taken by the learned advocate, the dealer has not paid the anti-tax as per the decision of the Honorable High Court Orissa is not accepted because he is not submitted by supporting evidence in favor of the dealer.
So anyway, so why would you not pay penalty then?
I have paid. I have already deposited.
Penalty, sir. Why would you not pay penalty is the question.
That I am coming.
That's the only question here.
That question I am coming. In that paragraph, that is answer. but the contention taken by the learned advocate in the dealer at the appeal hearing stage that since there is no purchase or sale suppression against the dealer under the Anti-Trust Acts, the penalty is levied by the LO is not tenable in law, has gone forth in because at the time of inspection of the vigilance, because I have not suppressed and the official has not detected any purchase of sale suppression against the dealer. And the dealer only withheld the admitted tax and purchase of machinery packing only, but not sale of finished product. It is found that dealer has paid the anti-tax on the sale of the finished product. Further, the dealer has also shown all this inside, outside purchase during the tax period under appeal. If any ill intention with the dealer, he have not shown the purchase of machinery and packing material in his books of account. So it is very clear that dealer intention is not bad, since the dealer has not suppressed the purchase of the above goods and not intentionally withheld the admitted. The dealer has not suppressed the purchase of goods and not intentionally withheld the admitted tax. In the interest of justice, equity, penalty as imposed by the dealer at rupees 1,95,000 is now deleted. First appeal has deleted, but as the dealer has withheld the admitted tax, I impose the interest of rupees 48,855 under section 5 and he imposed the interest. So after that, I paid the tax and interest. So now comes the section 10. Kindly have a glance to section 10. Section 10(2) that I have quoted in my petition also, my lord, page 5 of the
Entry tax.
Section 10(2).
Yes.
If the assessing authority is satisfied that the escapement is without any reasonable cause, he may direct the dealer to pay in addition to the tax assessed under subsection 1 by your penalty a sum equal to twice the amount of the tax additionally assessed under this section. So there should be a reasonable cause.
Yes, sir.
So this is my lord, in the case of NAVCO, kindly have the first question of law 2, whether imposition of penalty under section 43(2) of the OVAT can only be levied if the assessment is without any reasonable cause. So section 43(2) and section 10(2) is parameter. Kindly have a glance to 43(2), that is at page 4.
Yeah. Again, same. The word itself, the section itself says that.
Section that
without
page,
reasonable cause.
Yeah, my lord, reasonable cause. So if the assessing authority is satisfied that the escapement under the assessment account of the above is without any reasonable cause, he may direct the dealer.
That's right.
So it is not mandatory.
No,
so I have already paid the tax and interest.
It's not, nobody says it's mandatory, but it doesn't mean that you don't have to pay at all.
So there is no malified intention also.
No, the word used in the section is not malified, it's only reasonable.
Reasonable.
Let's not put a higher threshold when it is not there. The threshold is whether it's reasonable or not for you to withhold paying entry tax.
In the instant case, I have already, as per the Assistant Commission direction, after that I pay the tax and interest. So kindly have a glance to tribunal order.
Yes.
That is also not a speaking order. That is in the last page 4. Being the position law, we are of the considered view that the STO has rightly interpreted the provision law and rightly assessed the dealer discipline, but the learned DC has not applied his mind properly and reduced the tax demand without any reasonable nexus. So we feel it proper, quash the order of the DCCT and uphold the order of the assessment passed by the ST.
That's okay, sir.
Let's see.
No, 1 minute. So the question really is on a presumption that the High Court judgment excused you from paying entry tax, you've simply withheld the entry tax, correct?
My lord.
That understanding itself was erroneous.
No, that has been stated also.
Because the High Court had decided it by then. What is the date of the High Court judgment?
High Court judgment is
2010.
2008.
8. Must be.
That particular.
Let's see the judgment of the High Court.
Reliance Industries.
Indian metal.
Your Lordship, that is in the anti-tax book also, in the anti-tax book, that copy is there. That is at page 135. On the third, page 135, case number 3.
No, 135 some Prakash store.
Vigilance.
That is reported in 2008.
16
BST 85, page 85.
Date of order, sir.
Your Lordship,
Date of
that is
birth
also
18 February 2008.
Anti-tax book at page 135.
That is 18 February 2008.
So then you can't have it reasonably contend that after this judgment, you didn't have to pay income tax. Not that's the whole thing. The word is reasonable. That's all. Will dictate the order. No substantial question of law rests.
So then, my lord, if he is asking to pay as per the assessment order, so I have paid the interest, then that should be adjusted against my penalty.
No, penalty is separate.
Because they have called, because as per the tribunal has
please. All right.
Equal list item number 45.
My lord. The question of law is at phase 9 of my STRP, which has been admitted on 13/5/2013. And in the present case, the petitioner is a small-scale industrial unit manufacturing and sale of salted cashew nuts, and was granted with sales tax exemption on purchase of raw materials as well as on sale of finished products for a period of 5 years, with effect from 25th August 1997 to 24/8/2004. The original assessment for the assessment year 2000-2001 was completed under Section 12(4) of the OST Act, and the books of accounts and other relevant documents, and the claim of the assessee was accepted by the London assessing officer in the course of the original assessment, and the dealer was assessed to nil. Subsequently, on receipt of AG audit objection, the assessing officer reopened the assessment under Section 12(8) of the OST Act without any fresh material, and entire facts were on record while the original assessment was completed. The entire facts was there on record. Absolutely, there is absence of fresh material, and without any fresh material, basing on the materials available in the original assessment, simply on the dictate of the AG audit objection, he reopened the assessment under Section 12(8) of the OST Act. And this tantamounts the review of his own order. Then further, the second issue in this case is that there is non-application of mine by the assessing officer.
The audit report. The reopening was based on the audit report.
Yes.
So how do you say there's no fresh material?
Yes.
There is an audit report.
That is audit objection. And audit objection was there.
No, there's an audit report.
No, that is audit objection, not report. AG audit objection. That is not report.
And here it's written as
assessment order, it is AG audit objection. The assessment order is at page 12. The assessment of the above named dealer for the year 97, 98 to 2000, 2001 have been completed under Section 12(4) of the OST Act on 25th January 2001, then 30th March 2002, and 21/12/2002 respectively, resulting no demand. But as for the objection raised by the AG audit, due to under assessment leads to low government revenue.
No, but were these when the assessments were completed earlier, originally?
Yes.
Resulting in no demand. Were all these books examined or not?
Yes. All the books of accounts are produced. It was examined, and the first appellate authority also in his order reflected that they taking into consideration all the documents, the assessment record, the submissions made by he has also reflected that there is the documents proves that there is no fresh material, and without framing any opinion, independent opinion by the assessing of simply on the dictate of the AG audit, he has reopened the assessment, and the law is well settled in the case of Endure Limited, where it says no mechanical issuance of notice under 12(8) can be the assessment cannot be made mechanically. He has to give his independent opinion. And
the Learning Tribunal, after cognizing all these things, has restored the matter to the assessing officer.
Why should it? Why should it?
Your Lordship, because Your Lordship, the reopening has been, and the section 12(8) itself says, if for any reason the turnover of a dealer for any period to which the act applies has escaped assessment or
this escaping assessment, you have to form an opinion.
Yes, that has been formed, Your Lordship.
No, on the basis of new material, please, not on the same material. Otherwise, it's mere change of opinion.
Your Lordship, if there is a new material, that is the objection of AG.
No,
so
that is not material. Sorry, that is not material. In fact, even I was mistaken thinking it was a report. It's not. It's simply an objection.
Your Lordship, this Honorable Court has decided in many cases.
So show me one decision. In fact, on the other hand, the decisions say there has to be material.
In Uttareshwari Rice Mill, Your Lordship, that judgment.
How can it be merely on an objection?
In Uttareshwari Rice Mill, it has been decided already, Your Lordship. I'm sorry,
No, this Endure Limited clearly says.
Your Lordship, Endure Limited,
in addition to that, my Lord,
prior to that, Uttareshwari Rice Mill is there.
No. But Endure Limited, you have to answer
Your
this.
Lordship, let it be tomorrow. I may be permitted to produce that judgment. That judgment, Your Lordship, where assessment has been completed on a 12(8). Here it is 43. Endure Limited, here 43 of the OBAT Act, the 12(8), the same provision.
No, Endure Limited is 12(8), sir.
Yes, 12(8).
Just show him a copy of this 12(8).
Yes,
Endure
yes.
Yes, under 12(8).
And Uttareshwari has been considered.
Your Lordship, only that form of opinion that in the notice that may not be there.
No, there has to be material, fresh material, which you did not have earlier, which leads to forming an opinion about escapement of
so far as in this Endure, as well as Uttareshwari Rice Mill, this Honorable Court has decided.
Sir, it's been considered. No, that is there here. That Uttareshwari is here.
Your Lordship. Your Lordship, the AG audit objection can be a ground, but Your Lordship, that is a valid ground, but the assessing officer has to form.
Uttareshwari goes against you. I think what you're relying on is Bindlish.
Bindlish chemical. Your Lordship, I'm sorry.
So that Bindlish has been distinguished here.
Bindlish.
Para 9. But in Uttareshwari, the apex court specifically considered the provision. And the difference in the phraseology does not make much of a difference, but unfortunately, the attention of the division bench which rendered in Bindlish was not drawn. So it's already...
Any reason that AG audit report can be a valid reason.
No. There's not even a report, sir. There's only an objection.
Not. In view of the ratio, apex court in the judgment of division of Orissa, Bindlish Chemical Pharmaceutical Orissa, and reported in so and so, lays down a day. In fact, court Bindlish Chemical.
This is a very detailed judgment, sir. We are following this. Ugratara Bhojanalaya is the other judgment of this court. So I think consistently this court has held that there must be fresh material.
Not particularly fresh material, Your Lordship.
Yes.
I may be wrong, Your Lordship, but only that can be a basis, but assessing officer has to form an opinion.
No, but on basis of what? Not on the same material, sir. Otherwise it will be a change of opinion.
AG audit objection, Your Lordship, in all the cases.
Not a material. Objection is just an objection. It's not a material that you came across now on the basis of which
same material, but in all these
the objection
cases,
itself must be studying the same material and saying that this probably has escaped assessment.
Your Lordship, that finding, so far as the Income Tax Act, so far as this act is concerned,
so just go through Indore, no? The entire discussion.
But only the assessing officer has to form an opinion.
Yes.
That can be a reason, valid reason.
Yes.
So no new material, Your Lordship.
In fact,
I think
no.
Even the assessing officer has not framed any opinion.
No, that's right.
And simply on the dictate of the AG audit, he has reopened the assessment.
Correct.
But audit report can be a valid reason. Your Lordship, on that issue, on that count, I am arguing, Your Lordship. So far as that formation of Your Lordship, that is, Your Lordship is absolutely right. Formation of belief. But so far as whether new material is required,
yes,
on that reason, Your Lordship, I think all the judgments has stated that audit report, audit visit, audit objection can be a valid reason.
No, just see para C, 15 para C. All answered here. In fact, this judgment is a complete answer to everything that you are arguing.
Your Lordship.
Complete answer.
That is my argument.
Complete answer.
Of course, Your Lordship, that is my argument.
No, read it, sir.
Of course, audit objection can be a valid factor which can be taken into consideration by the consular for initiation of proceeding of reopening of assessment. But the concerned sales tax officer must independently apply his mind and form an opinion that on the basis of audit objections, an order for reopening of assessment can be passed. This should be a valid basis for reopening, but the sales tax officer formation cannot be dictated. The audit cannot be dictated by audit objection.
Correct.
That Your Lordship, I am bowed down. But Your Lordship, what Your Lordship finding that new material is required. New material is required, Your Lordship. For that reason, my respectful submission, Your Lordship. So that can be a basis, Your Lordship. Valid basis, Your Lordship. Only my submission is that. So that finding, Your Lordship.
We'll just follow this judgment, sir.
Your Lordship. Your Lordship may follow. But so far as the new material, Your Lordship.
You say this is an SSC's revision petition directed against an order dated 15th October 2012 passed by the Orissa Sales Tax Tribunal, In the appeals, there's only one appeal here, is it?
One.
There are 3 years.
There are 3 appeals, but this 27 has come in the list.
Where are the other appeals?
Appeals are there pending.
Which are those?
I think that is 26 up to 2013 and another is 28 2013.
So why don't we take it on board and dispose it off in the same terms?
Yes.
Just take 26 and 28.
26 of
Just see it's
2013.
pending. No? These 3 revision petitions by the SSC are directed against the judgment dated 15th October 2012 passed by the Orissa Sales Tax Tribunal, Tribunal, allowing the state's appeals essay numbers 302, 303 and 304/2008-09, thereby reversing an order dated 22nd December 2007 of the Assistant Commission of Sales Tax (ACST), Puri, allowing the SSC's appeals against the demand raised by the sales tax officer (STO) Puri Circle for the years 99-2000, 2000-01 and 2002-03 respectively. Paragraph. While admitting this revision petition on 17th April 2013, the following questions of law were framed by this court. Paragraph. The background facts are that the SSC is a processing unit dealing in finished products like salted and spiced cashew nuts, which it makes from cashew kernel, oil, iodized oil, and spices, salt and spices. For the years in question, the STO initially completed the assessments after examining the books of the SSC and raised nil demands on 25th January 2001, 30th March 2002, and 12th December 2002, respectively. Subsequently, on the basis of the objection of the AG audit, the assessments were reopened under Section 12, bracket 8 of the Orissa Sales Tax Act 1947, OST Act, pursuant to which the dealer appeared, produced books of accounts, on the basis of the reopening, the fresh assessment orders were passed by the STO for the 3 years in question, raising demands on the basis that there had been an escapement of turnover earlier. Paragraph. The SSC's appeals were allowed by the ACST. Pointing out that a stereotype order has been made in respect of all the years. And the order had been passed on the last day of the year in question, just to avoid time limitation. The formation of opinion by the STO was also without any signature on the order sheet. He simply stated, open quotation, due to AG audit objection, the initiation of proceeding under Section 12, bracket 8 was made for favor of information. Stop, unquote. Paragraph. The state then filed appeals before the tribunal. Agreeing that, open quotation, the orders of assessment have been passed in a hurry and communicated to the dealer respondent in a belated stage, nearly after 1.5 years, which has rightly been observed by the learned ACST. Unquote. Further, it was noted by the tribunal that the STO, open quotation, has also not mentioned the points of objection raised by the AG audit and just mechanically reopened the case under Section 12, bracket 8 of the Act for the year 1997-98 to 2000-01 with demand of taxes, whereas the dealer is eligible to enjoy tax benefits both on purchase of raw materials and on the sale of finished products for a period of 7 years from 25/8/97 to 24/8/04, unquote. Paragraph. But the tribunal also found fault with the ACST for annulling the assessment orders without assigning reasons, open quotation, with reference to the exact objection raised by AG, unquote. And according to the tribunal, the STO and the ACST did not properly interpret the provision of law with reference to exemption allowed by DIC, an objection raised by AG bracket O, paragraph. As a result, the cases were remanded to the STO for a fresh adjudication, paragraph. This court has heard learned counsel for the parties, paragraph. Section 12 bracket 8 of the OST Act reads as under. This has to be read with Rule 23 of the Orissa Sales Tax Rule 1947 bracket rules, OST rules, which reads as under. The jurisdictional requirement A2 and B2 of the STO having to form an independent opinion regarding escapement of assessment was explained by this court in the Indure Limited versus Commission of Sales Tax 2006 148 STC 61 bracket Orissa. So in that case also, the assessment was sought to be reopened by the STO under section 12(8) of the OST Act only on the basis of an audit objection without forming any independent opinion himself regarding escapement of turnover. Full stop. Paragraph. This court referred to the judgment of the Supreme Court in Sales Tax Officer Ganjam versus Uttareshwari Rice Mills, Manu /SC /0556/1972, where it had been explained that the difference of phraseology between single quotes for any reason, unquote, appearing in Rule 23 bracket 1 of the OST rules, and open quotation, if the sales tax authority has reasons to believe, unquote, as appearing in section 12 bracket 8. Does not make much of a difference. Full stop. It was also noticed that an earlier division bench of this court in Bindlesh Chemical and Pharmaceutical Works versus Commission of Sales Tax Orissa, 1993, 89 STC 102, had not noticed the above decision of the Supreme Court in Uttareshwari Rice Mills, Supra. Paragraph. In Induri Limited, Supra, this court also noticed a subsequent division bench. Subsequent decision of a division bench in state of Orissa versus Ugratara Bhojanalaya, 1993, 91 STC, 76 bracket Orissa, which explained the requirement of section 12 bracket 8 of the OST Act in consonance with the decision of the Supreme Court in Uttareshwari Rice Mills, Supra. Paragraph. In the Induri Limited, Supra, this court summarized the legal requirement notice that in Ugratara, Supra, the division bench of this court summarized the legal position is under C to C. Paragraph. Again, in para 18 of the judgment in the Induri Limited, it was explained as under. B to D. Paragraph. Ultimately, the impugned notice of reassessment was quashed since the sales tax officer had single quotes blindly initiated, unquote, the reassessment proceeding on order to objection, open quotation, without any independent application of mind, unquote. Paragraph. The facts of the present case are more or less similar. We'll stop here again as seen in the order of the ACST. The reopening of the assessment was made by the STO only on the basis of the audit objection and without any independent application of mind as to whether there had been an escapement of turnover for the periods in question. Stop. Following the dictum in the Induri Limited Supra, this court is of the view that the reassessment orders of the STO cannot be sustained in law. The tribunal erred in remanding the matters to the STO when the jurisdictional requirement of recording of satisfaction by the STO in the manner explained in the Induri Limited was non-existent in the present cases. Consequently, question number 1, question A framed by this court is answered in the affirmative by holding that the STO had mechanically issued notices under section 12 bracket 8 of the OST Act. In view of the conclusion in question A, as a result of which the impugned reassessment orders have been set aside with this court. The discussion on question B is rendered academic and is therefore not answered. And that question is therefore not answered. Paragraph, the net result is the orders of the STO and the tribunal are hereby set aside, and the order of the AC/ST is set restored to file. The revision petitions are disposed of in the above terms.
STRB 26 and 28.
Yeah, all three are together. Yeah.
Quick list item number 46.
Item number 315 days delay.
Delay of 315 days has not been properly explained. The delay is condoned, consequently the revision petition is dismissed.
Quick list item 47.
None appears dismissed now.
Item 48.
48, Your Lordship, 20,424.
The tax effect being insubstantial, the question of law left open and the petition is disposed.
Quick list item 49.
So, this file could not be tested out by 1 week, 2 weeks time.
For what, sir?
For item number 49.
Why?
That file could not be tested.
No. We'll give you the file, sir.
Yes, I will argue.
We'll give you the file.
I'll argue, man.
Yes.
Very short question, man.
Yes.
On 21/2/2014.
Yes.
Your Lordship, the following question of law was admitted.
Yes.
Whether on the facts, the circumstance of the case, the division bench of the tribunal is right in law in holding that the entry tax paid and being allowed as a set-off under Section 4(2) of the Orissa Entry Tax Act 1999 forms the part of gross turnover, taxable turnover.
This we answered yesterday, na? That it's not includable in taxable turnover.
Yes.
Yesterday we've answered it.
Your Lordship, but here,
Here, same thing.
no.
I paid entry tax.
Only yesterday we've answered it.
No, in that case, that has been paid.
Here it is paid.
Entry tax has been paid. Here,
Yeah, the entry tax paid and allowed a set off.
Yes.
It's paid. Even here it's paid, sir.
yes. Your Lordship.
You see, on 21st January 2014, the following question was framed for consideration by this court. Paragraph. In view of its reportable judgment, what we passed.
I'm passing it. Just obligement.
No. Yesterday we passed a judgment. You have a copy of that. In view of the judgment passed by this court on 12th July 2022 in STREV so and so. The above question is answered. In the negative. That is in favor of the assessing against the department. The impugn order of the tribunal is accordingly set aside. The revision petition is allowed in the above terms.
Weekly list item number 50.
None appears this was an office question. Both matters. Three matters.
Weekly list item number 51.
Your Lordship, that is 10,242.
The tax amount being insubstantial. The question of law is left open. The petition is disposed of.
Weekly list item 52.
Many defects are there, not removed for a long
defects have not been removed for over 8 years now. None appears for the petitioner. Dismissed for non-prosecution.
Weekly list item 53.
Wait, please, Millards. Lordships, the name of Mr. Sahu is not reflecting in the cause list, Millards. So that is the reason we have missed this matter, Millards.
Today morning.
Plus, we just seek one shot at gentlemen.
Or at next Wednesday.
Deeply obliged, Millards.
Weekly list item 54.
Item 54. Your Lordship, item number 54, the question of law. The question of law is at page 11. Whether in the facts and in the circumstances of the case, Orissa Sales Tax Tribunal aid in law by holding that assessing authority has travelled beyond the terms of audit which it report, particularly when the assessing authority has determined the liability basing on the books of accounts and document produced by the assessee opposite party. And second question, also the same in conformity in terms of, now your lordship may kindly turn to the finding. Finding of the your lordship tribunal. Considering rival submission, your lordship, that is at page 29.
Right.
It starts from page 29. And page 30, your lordship, by cognizing that Bhushan Power Steel Limited, wherein the Honorable Court held that the assessment is certainly an audit assessment, the assessing authority is obliged under the statute to make the audit assessment on the basis material available in the audit report. The assessing authority cannot travel beyond the material available in the audit report. Utilization of any other material for any other source is completely foreign to the audit assessment and same is not permissible. Therefore, it is crystal clear that opposite principal assessing cannot.
They've only remanded, sir.
Your lordship, it has been remanded based on the finding, your lordship. Now, your lordship, what happened in that Bhushan Limited, your lordship, what has done in the assessment? No other material have been considered. Your lordship, audit has been made. Your lordship, under section 41, audit has been made. Audit officer has submitted its report. So, based on that report, under section 42, assessment has been initiated. So, assessing officer has issued notice pursuant to audit. Your lordship, the books of accounts has been verified, has been called for by the assessing officer. Has been
verified. Page 30 bottom.
Your lordship.
Come to the bottom of page 30.
Your lordship.
In our considered opinion, that line.
In our considered opinion, the assessment to the extent of suppression is to upheld being the allegation contained in the audit which report. But so far as the observation of the learned assessing authority on other counts like damage strucks, reverse ITC are challenged on behalf of the appellant is concerned, the same can be considered by the learning under the appropriate provision of the Overhead Act, your lordship.
No, just read the last three lines. As the same do not form part of the AVR.
Audit visit report.
And only that, for that it has been remanded.
Your lordship, my respectful submission, your lordship. So, tribunal has said that you have to restrict the addition so far as the audit report. Beyond audit report, you can initiate any other proceeding. So, that is the finding of the tribunal. So, my respectful submission, your lordship, those other additions are out of the books of accounts, your lordship. So, if that cannot be done, if that can be restricted to the assessing officer, then what is the necessity of calling of the books of accounts? Then what the assessing officer will do?
No, but he has to confront the assessee with it. He can't simply go
beyond. That has been confronted. Your lordship may kindly turn to the assessment order. What has been done in Bhushan case?
So we're not interfering. We're not interfering. You say the tribunal has only remanded the matter to the assessing authority.
Your lordship may kindly peruse the Bhushan
for reconsidering the issues concerning open quotation, damage stock, reverse ITC, etc. unquote. Since open quotation, the same do not form part of the audit visit report.
Your lordship, with great
while upholding
Honorable Supreme
the
Court,
additions on the basis of the allegations contained in the audit visit report.
Your lordship, Honorable Supreme Court has already, so far as that Bhushan, after Bhushan judgment, we have gone to before Honorable Supreme Court in Vedanta and Bhushan judgment. And in those judgment, Honorable Supreme Court in interim order has directed to make assessment, including all those documents, all those evidences, all those documents, your lordship. Your lordship, I may be permitted to submit that judgment of Honorable Supreme Court, that order of Honorable Supreme Court. Your lordship, in this case, in Vedanta case, that is Bhushan order, your lordship, Bhushan judgment. This case is in Vedanta. Honorable Supreme Court has held that the assessment can be done And Bhushan case is also something different, that there is a fraud case report that has been
No, it will
cognized.
be open. Final, it will not be passed without.
Your Lordship, not
This is an
passed.
interim order.
Not passed, Your Lordship.
This
But
is
that
an
is
interim
pending before Honorable
It's
Supreme
just an
Court.
interim order saying it can go on, but no final order will be passed.
Your Lordship, but that whether
The court is
after-
therefore not inclined to frame any question as urged by the department. Revision petition is dismissed. All right.
Weekly list item 55.
55, Lordship, is the same as STREV 68 of 2004, 10th of April 2019, Lordship, electricity meter, transfer of right to use, Lordship. This, I answered this question already.
We're not able to understand anything that you've said. What do you want to say?
Lordship, in 55, Lordship, STREV 68 of 2004, this Honorable Court has already answered the question. This pertains to taxing transfer of right to use of electricity meters, Lordship.
In view of the order dated 10th April 2019 passed by this court and STREV 68 of 2004, the present petition is dismissed. All right.
Weekly list item 56.
56 and 57, my lords, have answered this question by order dated 6/7/2022.
Your Lordship, this is regarding the delay in service, Your Lordship. And so for the judgment of Honorable Supreme Court, that there must be some reason. Lordship,
Correct.
But Your Lordship, in this case, the tribunal has stated that, and also I have to find out the reasons on the cases.
The answer, sir, let's be consistent with this.
Your Lordship.
Has questions been already framed in this?
Yes, ma'am.
You see, in view of the decision of this court dated 6 July 2022 in STREV 100 of 2013, the questions framed with this court in the present petition by order dated 18th August 2014 are answered in favor of the SSC and against the department. The revision petition is disposed of. The same questions, in fact. Right. 56 and 57.
Weekly list item 58.
None appears dismissed, non-possible.
Weekly list item 59.
None appears dismissed, non-possible.
Weekly list item 60.
My lords, item 60, I am appearing for the petitioner, my lords. This is covered by my lord's judgment passed in Keshav Automobiles, my lords.
He says it's gone, they've gone in appeal.
Lordship,
stay is granted.
Unfortunately, today I have received the message from Honorable Supreme Court, my advocate, that Your Lordship's order has been confirmed, but let it be one day or 2 days next week. Your Lordship, let it be next week.
Let him get the order.
Let me get the
Okay,
order.
at the request of counsel for the state, list next week. All right.
Your Lordship.
That's also the message that is also the message which we received.
I see.
Justice M.R. Shah and Justice.
Yes.
All right.
Weekly list item 61.
My lords, item 61, the petitioner sells fishnet, my lords. Fishnet is
Did you pay the deficit court fee, sir? 100 rupees.
My lords, I'll pay, let it come next week. Today I will.
All right. Yes. Deficit, fishing net he sells.
My lords. Fishing net, my lords, the first appellate authority came to the findings that it is not a scheduled goods for entry tax, my lords. But the appellate second in the state carried second appeal, my lords, there he has not followed the full bench judgment of the tribunal, where it has been held that fishnet is not coming under the purview of entry tax, my lords. And that judgment is challenged by the state. And
let him examine it. You say, counsel, the petitioner states that he'll pay the 100 rupee deficit court fee within 1 week. Paragraph notice, Mr. Owens accepts notice. List on 17th October.
Weekly list item 62.
None appears to is non-possible.
Weekly list item 63.
No instructions.
Counsel petitioner states yes, no instructions. It's disposed of.
Item 64.
Item number 64, Your Lordship. Your Lordship. Your Lordship, may kindly turn to the tribunal's order. Your Lordship, that is at page 46. Only one interpretation, Your Lordship. That's Rule 40, Rule 41 of Orissa Value-Added Tax Act, Value-Added Rule says that the formation tax audit under Rule 41 shall be undertaken by a team constituted for the purpose of such audit team may consist. Only this is Your Lordship's wisdom, may consist of one and more assistant commissioner, sales tax officer, and assistant sales tax officer of the as the commissioner may deem fit. So the case is that here no assistant commissioner. Only that constitution, the audit team has been constituted. Sales tax officer, assistant sales tax officer, so and so, no assistant.
No, may meaning one or more. May is for one or more. Not that there should be no assistant.
May consists of one and more.
That's right. May means that it could be more than one. Not that there should be none.
Your Lordship, for that reason I have.
All right. The state has filed this revision petition questioning an order dated 3rd August 2013 of the Orissa Sales Tax Tribunal, Cuttack, in essay number 192 bracket VAT of 2011-12, which has invalidated the assessment on the ground that the audit team that undertook the audit visit was not properly constituted in terms of Rule 43 of the Orissa Value-Added Tax Rules 2003. Paragraph. The said rule reads as under. The contention of the learned counsel of the state is that where does it say may, sir?
Your Lordship, that has already been amended. Your Lordship,
it's been amended.
VAT Rule 43.
So the amended makes it shall now.
No. But may consist. Your Lordship, may is in between. Shall be undertaken by a team constituted for the purpose, and such audit team may consist of one or more assistant commissioner, sales tax officer, and assistant sales tax officer as the commissioner may deem fit.
That's right. This stood prior to 25/2, 2009.
2009. So this period is also prior to 2009.
No. The year in question here is the period in question here is 1/4/2005 to 30/8/2008. And for that period, Rule 43 stood thus. Just take 8 to A.
And also, Your Lordship, one respectful submission, as the commissioner may deem fit.
Yeah.
So here, the discretion
it may be noted here that subsequently, with effect from 25th February 2009, Rule 43 has been substituted, and now Rule 43 bracket 2 mandates that the audit team shall comprise 2 or more officers, one of whom shall not be below the rank of STO. Paragraph. At the relevant time, admittedly, in the present case, where the audit team was assembled, it did not consist of any assistant commissioner at all. The contention of the tribunal found, therefore, the team to be not properly constituted and declared that the visit undertaken by such audit team would not be sustainable in law. The report submitted by such audit team would not be sustainable. Paragraph, it sought to be contended that the word may preceding the words open quotation consists of one or more assistant commissioner, unquote, gives discretion to the commissioner to completely exclude the assistant commissioner. Full stop, the court is unable to agree with this interpretation. Full stop, the word may qualifies the words open quotation one or more, unquote. The discretion of the commissioner is limited to deciding whether there should be one or more assistant commissioner.
Then you'll also
Full stop.
one more
That view of the
aspect,
matter, the court is unable to find any error having committed by the tribunal.
retrospectivity one more.
No, it's okay. The no substantiation of law arises, the petition is dismissed. Right.
Quick list item 65.
None appears dismissed, non-prosecution.
Item 66.
May I please, Your Lordship?
Yes.
Well, the question of law has been framed by Your Lordship, order dated 27/11/2015. There's two questions have been framed. First is whether on the facts and in the circumstances of the case, the petitioner being an SSI unit is liable to tax at the rate 2% by notification number such and such dated 31/3/2001, read with notification number such and such dated 16/6/2006 for goods manufactured and sold in course of interstate trade and commerce derived out of custom milling. Second question, my lords, whether on the facts and the circumstances of the case, the tribunal is legally justified to hold that the rice bran and broken rice derived out of custom milling paddy cannot be treated as goods manufactured by the SSI unit for the petition of the petitioner matter. Lords, what has happened? I'm a rice miller, my lords. I procure rice from various agencies such as Civil Corporation, FCI, and convert it to rice, paddy to rice, and in turn, I get some commission. During this process, my lords, some byproducts such as bran and broken rice are remains there. Since the agency only take the rice that remains with me, my lords. That in course of the business, I sell that in that product I sold that. Assessing officer says that these products, which are the byproduct in derived from the manufacturing of paddy to rice, is not your own product, my lords. Therefore, he doesn't give the effect of the notification, though he taxed me at a higher rate, but not at the notification. My lords, kindly see the notification, 8.5 notification, which give at annexure 3, my lords.
No. So he's taxing it at what percentage?
4%. Lords.
Whereas you're saying it should be 2%.
Yes, ma'am.
The notification did not include this brand, I'm sure.
My lords?
The notification was to incentivize making rice out of paddy.
No, my lords. The notification just says that if I'm an SSI unit selling the goods in course of interstate sales, that's it.
Doesn't say the product.
No, my lords.
Let's see the notification.
Page 30, my lords. This is the 8.5 notification, my lords. I stand on clause 6. It is at 31. Goods manufactured by small scale units in the state of Orissa when sold directly. When sold directly in course of interstate sale. So he taxes at 4%. My claim is 2%. First appellate authority allowed my claim. He says that if I am not the owner of the goods, then how can I procure, get the C for my lords and submit to before the assessing officer? The tribunal held that this is a part of my commission, but doesn't give the effect.
So it's all only in relation to that bran.
Bran and broken rice.
Broken rice.
So that is not the question here, Your Lordship. At page 72, the tribunal's order, paragraph 3. The question is here whether the rice, bran or broken rice received out of custom milling.
Correct.
when sold in course of interstate trade or commerce is to be taxed at a concessional rate of 2%.
Correct.
So
that's what is arguing.
Your Lordship, both the forums below have observed the disputed that rice, bran or broken rice have been received by the dealer from the custom milling. Though both the orders have not indicated anything regarding the receipt of rice, bran or broken rice custom milling on payment of monetary consideration, it is an understanding between both the customer and the miller that in spite of payment of commission, the miller will retain the byproduct such as rice, bran and broken rice, which goes without saying the above goods were also received against monetary consideration. Now the question arises whether such goods received by the dealer from the custom milling can be treated as goods manufactured by SSI unit or by unit of the dealer respondent, which is also a SSI unit. In deciding the above issue, we are of the opinion in the disputed goods which are obtained out of custom milling and also on payment of consideration, same cannot be treated as manufactured goods of the dealer's unit. Hence,
who else? It is coming from the dealer's unit only. So it's only when the milling happens that this comes as a byproduct.
Your Lordship, byproduct, but byproduct is on for a consideration, Your Lordship.
No. What they're getting is only paddy, sir. No, they're getting paddy and making rice from paddy.
The byproduct has a value.
No. The value is realized only when the sale happens.
Your Lordship, that has not been disclosed, no? But that
No. They're paying tax at 2% on it. They're disclosing those sales, they're paying tax at 2%.
Yes,
you're saying no, it should be taxed at 4%.
4%.
All right. See, this is an SEC's revision petition against an order dated 6th July 2013 passed by the Orissa Sales Tax Tribunal in essay number 58 bracket C oblique 2011-12 for the period
my lords.
1/7/2006 to 31/12/2007. While admitting this revision petition on 27 November 2015, the following questions were framed for consideration. Paragraph. Admittedly, the SSC is a rice milling unit which procures paddy and makes rice from paddy by milling. As a byproduct, this process also generates for the SSC rice bran and broken rice. Being an SSI unit, admittedly, the SSC has the benefit of a notification dated 31st March 2001 of the Finance Department of the Orissa, of the Government of Orissa, where this is 1%, it says, is subsequently revised to 2%.
Subsequently, by 16 June 2006, it has been raised to 2%.
Yeah, where inter alia, goods manufactured by SSI units in Orissa, when sold directly or marketed by the Orissa Small Industries Corporation, after purchasing the same from such SSI units, were exigible to a concessional rate of sales tax at 1%, subject to production of declaration in Form C, when sold in the course of interstate sale or commerce. Full stop. By a subsequent notification dated
16 June 2006.
16 June 2006, this was revised to 2%. Paragraph. Admittedly, the SSC has sold the broken rice and bran to customers by way of interstate sales and is claiming concessional rate of sales tax at 2%. Full stop. While the ACST in appeal allowed this plea of the petitioner, the tribunal appears to have reversed the order of the ACST by the following reason. This is reproduced para 3, page 72-73. Paragraph. Having heard learned counsel of the parties, the court is of the view that the above observations proceed on a surmise that there was an understanding between the customer and the miller, bracket that is the SSC, that the miller would retain the byproduct such as rice bran and broken rice. Full stop. The observation that it, open quotation, goes without saying that the above goods were also received against monetary consideration, unquote, defies logic, since what was purchased by the SSC was paddy and not rice bran or broken rice. These were byproducts as a result of the milling of the paddy by the SSC. Full stop. There's no question, therefore, of rice bran and broken rice being purchased by the SSC for, single quotes, monetary consideration, unquote, full stop. It is plain from the processes deployed, that is custom milling, that the byproducts, namely rice bran and broken rice, resulted from that process, and therefore were goods manufactured by the SSC and then sold in the course of interstate trade or commerce. Full stop. Consequently, the court is of the view that the SSC was entitled to on such interstate sales of rice bran and broken rice, to have a concessional rate of sales tax at 2% in terms of the aforementioned notification dated 31st March 2001 as further modified on 16 June 2006. Paragraph. Consequently, the questions framed are answered in favor of the SSC and against the department. The impugned order of the tribunal and the corresponding order of the STO are hereby set aside. The order of the ACST is restored to file. The petition is disposed of.
Obliged. Weekly list item 67.
67, Your Lordship, Your Lordship just now has seen that meter. It is against the revenue. It is just as like as item 50, 55.
All right. In view of the decision dated 21st June 2022 in STREV 67 of 2009, this petition is dismissed.
68 is 68 is paltry amount.
Or in view of the insignificant substantial tax amount. Question to law is left open and the petition is disposed of.
69, Your Lordship, that is
dismissed. Yeah.
45.
None appears.
Paltry amount.
Weekly list item 70.
Lordship may kindly see the order dated 9/7/2015 by what happened, Your Lordship? Due to inadvertent type mistake, the order on miss case number 89 of 2015, by the order dated 28/2015, the question number 1 and 2 had been substituted. Whether on the facts and the circumstances of the case, the law and judicial member of the Orissa Sales Tax Tribunal is right in law in holding that petitioner is liable to pay tax under section 12 of the VAT Act in respect of goods received at a free of cost under sales promotion scheme of another registered dealer under the Act. The question number 1 and 2. The question number 3 is whether the tribunal justified levying penalty equal to twice the amount of tax under section 42(3) and stroke 43(4) of the Act. The brief facts of the case, right? Lordship, is an audit assessment for the period 1/4/2005 to 31st December 2018. Your Lordship may kindly see to appreciate the case assessment order under Annexure 1. Running page 40. That is the point of case. Your just second para, just after 10 lines, middle of the, it was observed that all purchases and sales, does you find it? Running page 14.
Yes.
Have effected by the dealer within the state of Orissa. On examination of books of accounts, it is detected by the audit team the dealer has received the goods on free distribution from the company as an incentive scheme on tax invoice. He has received the goods as a free goods on tax invoice and supplied the same free of cost to the customer at the time of sale. The said incentives goods are mentioned in the tax invoice, which included in total value on which they have claimed ITC. Therefore, dealer in the instant case is liable to pay VAT.
This is like free, something coming free with the product.
Yes, my lord.
No, tax invoice. He has purchased by giving
but the free has come. It has come as a free thing with that.
Under Annexure 4, I have
Let's see, audit on examination of audit team, the dealer has received the free distribution from the company as sale incentive scheme on tax invoice.
Yes.
So tax invoice means he has paid the tax.
No.
Tax and supplied the same free of cost to the customer at the time of sale. The sale
No finding has been given by any forums. And simultaneously distributed at free of
No. So the copies of the purchase invoice and sales invoice are there. Just see that.
Annexure 4, my lord.
Annexure 4.
Annexure 4.
ITC has been claimed.
In the column
But that
10,
reason I have submitted.
free quantity. That has been produced before the tribunal level and recorded their findings also. There is no dispute.
Where does it say free quantity?
You'll also find it annexure 4, running page 23. You'll also find it.
Yes.
Just column 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 column. Free quantity.
Free quantity. Correct.
Yes. Then
So he's paying tax on the other quantities, and these free quantities are shown separately. There's no tax paid on it.
Then your lordship will kindly see.
Only my
Annexure
submission that IT, therefore the dealer instant is liable to on sale because on short sale because ITC claimed on purchases. ITC, for that reason, I have submitted that since tax has been paid and also tax invoice. Oh, if that is free, that can be purchased. That cannot be purchased through tax invoice.
No, it has to be shown somewhere. How did he get it is the question, right? It has to be shown in some document. It has to accompany the consignment, right?
Tax invoice.
Then your lordship may kindly tax invoice issued by the petitioner. Page 25, 2 pieces free, 2 pieces free, 50. All have examined. On basis of mere presumption, the sales tax officer held that there must be sales operation. Correct.
And that is again supplied free. It's like, let's say you buy a bottle of oil and you get it soap free, right?
Yes.
On the oil you're paying sales tax, but this is supplied free to you as even as a dealer. And to your customer, you will still give it as free only. It's not selling it.
Your Lordship, in
that whole scheme of that.
In all this forum, tribunal also has given the finding that no evidence has been produced. Your Lordship, may kindly turn to page 30.
These invoices actually show free.
Your Lordship
has examined all invoices.
Your Lordship, may kindly turn to tribunal's order at page 34. The last page 35, filed any adverb leaflet, any page 35, just beginning. No such document is also filed by the dealer appellant report to justify the contention that it has received any goods as free gifts and supplied the same to the customer as free gifts.
No, there is a document. Where do you get these documents then? All these invoices,
on paragraph 7 of the
Annexure 4,
paragraph 7 of the tribunal order. At the time of hearing the appeal, the only contention raised for the dealer appellate is that the dealer has received some goods as incentives, and these are free gifts received from the company without passing any consideration, and dealer has subsequently transmitted the same to retailers free of cost for the customers, and these incentives are directly given to customers by the company. As such circumstances, there is no sale or purchase in respect of such free items of goods. Imposition of VAT there is illegal. In order to fortify such contention, the dealer appellant has relied upon some Xerox copies of invoices alleged to be issued by the Dabur India Limited, besides some retail invoices, which reveal on one column as free quantity. The tribunal observation at page 7.
No, it is submission.
He observed.
And your lordship, the matter has been remanded to the Law and Assessing Officer for fresh computation of tax liability.
Not
so your lordship,
not for
so
only for tax liability.
Let
I'm
it-
saying that this
let
has to
it
be.
your lordship, your lordship. that is
No.
absolute- Your
Only
lordship, let it go to the tribunal.
Tribunal
Let it
read
go
the
to
tribunal order.
tribunal for
Only in respect of
consideration.
your lordship, only 8,240 I had paid, not adjusted, not taken into consideration by the assessing officer. That part has been remitted back to the assessing officer. If the appellant has paid the amount, it should have been credited. That is the only remark. But these things he has offered that the assessing officer as well as assistant commissioner have rightly assessed the dealer.
Your lordship, if 8,000 will be allowed, then balance is 20,000. So 20,000 for 20,000.
The penalty is 50,000. Penalty is twice
20
the
and
tax
40.
demand. Total is otherwise I would have considered before this honorable court that this is below 20,000. Below 50,000.
What is the total amount you have to pay?
Tax amount, your lordship, 28,595.
So out of
which 8,000 some odds I have
out of
deposited.
20,000, 8,000 he has already paid, so that has to be allowed. Nobody can
And
say
the
that
balance
cannot be
is
allowed.
57,190 on free gifts. They have imposed penalty on penalty me. That's why the lordship at the time of admission stayed the penalty.
Your lordship, penalty is mandatory. So only once assessment has been completed.
But it's the audit assessment 42.5. So unless the main assessment goes, this will stay.
It will stay on.
But since some facts are required for verification, your lordship,
They are all there, sir. The entire invoice is there, Annexure 4.
And the audit has examined the entire invoices and quantified their observations. This is the audit assessment. On the basis of audit report, the assessment has been framed and the observation of the audit report has been reflected in Annexure 1. Running page 14.
All right.
Dabur India is a
The
registered
SSC has
dealer.
filed this revision petition against an order dated 16 January 2013, passed by the Orissa Sales Tax Tribunal, Tribunal, dismissing the SSC's appeal essay number 251, VAT of 2010-11 for the period 1st April 2005 to 31st December 2008. Paragraph. The dealer is a proprietary concern.
It is partnership concern. Wrongly it has been done. It's a partnership.
What are you saying, sir?
It is a partnership concern.
Okay. The SSC is a partnership concern carrying on business in honey, glucose, Colgate, EU of Amul brand on wholesale basis. Paragraph. On receipt of an audit visit report, (EVR), the Assistant Commissioner of Sales Tax, Bhubaneswar 4 Circle, Assessing Authority, A, initiated proceedings under Section 42 of the Orissa Value Added Tax Act 2004 (OVAT Act). Paragraph. When the audit team visited the petitioner's business premises, it detected that all the purchases and sales of the dealer were semicolon that the dealer had received some goods from the company free of cost on sales incentive scheme and had supplied the same free of cost to the subsequent purchasers. Full stop. The incentive goods reflected in the tax invoice included total value of goods on which the dealer had claimed input tax credit. And since the dealer had claimed ITC on purchase, he was liable to be paid VAT on such sales. The sum of such incentive goods was calculated as rupees 376,458. Stop. The AA accordingly computed the tax liability and inclusive penalty raised a demand of, under 42(5) of the OVAT Act, raised a demand of 85,785. The appeal of the SSC was rejected by the Deputy Commissioner of Sales Tax by an order dated 17 June 2010, after which the SSC went in appeal before the tribunal. Paragraph. Although the tribunal noticed that the SSC had relied on certain invoices which showed that the goods were received as free gifts on which tax had not been paid, the tribunal concluded, open quotation, no such document is also filed by the dealer appellant before this forum to justify the contention that it has received any goods as free gifts and supplied the same to customers as free gifts. Full stop. Accordingly, comma, there is no proof that the dealer has dealt with any goods as free gifts, unquote. Paragraph. While admitting this revision petition on 9 July 2015, the following questions were framed by this court. No, certain questions were framed by this court, which were later modified by the order dated 20th August 2015. Stop. The first question is, open quotation, whether on the facts and in the circumstance of the case, the learned judicial member of the tribunal is right in law in holding that the petitioner is liable to pay tax under Section 12 of the OVAT Act in respect of goods received at free of cost under the sales promotion scheme from another registered dealer under the Act, question mark, unquote. The other question relates to the validity of the order levying penalty on the petitioner under Section 42(5) of the Act. Paragraph. Before the authorities, that is the AA and the DCST, the SSC had produced the tax invoices from the dealer, received from the dealer, from whom it had purchased the goods. And as part of the sales incentive, there's a separate column in the said invoice, which shows the goods received free. The column is titled single quotes free quantity, unquote. Likewise, in the retail invoices issued by the petitioner, the pieces supplied as free are separately shown in the invoice itself. Full stop. Despite these documents, the tribunal erroneously observed that no documents were produced by the petitioner to show that it had purchased under tax, it had been supplied by the dealer under the tax invoice as part of the sales incentive scheme, goods that were free and in turn, while affecting retail sales, supplied such goods free to the customer. Full stop. The observation of the tribunal to the contrary appears to be not supported by the record paragraph. The very basis of the tribunal, therefore, upholding the orders of the AA and the DCST is based on the surmise that, open quotation, the value of such goods must have been included in the purchase price on which the dealer has paid VAT at the time of purchase, unquote. From the invoices produced on record, which also forms part of the assessment record, it is plain that on the free quantity, VAT has not been paid at the time of purchase. And the goods received as free gifts have been supplied to customers as free gifts. Paragraph. For the aforementioned reasons.
Your Lordship, one more submission,
Yes.
Submission, Your Lordship. Your Lordship, that 8,064, so far as the levy of penalty is concerned, Your Lordship, so that 8,064 has been deposited after the audit, Your Lordship, at the time of assessment, Your Lordship. So penalty may be restricted to that 8,064. So far as the pre-gift, since Your Lordship has allowed that, so penalty will be deleted. So that question may be answered by restricting that penalty. Since
so let the 8,064 be not saying anything, but why should there be a penalty on that?
And if Your Lordship
there's no question also framed on that.
Your Lordship, the tribunal has restored the matter for calculation of that to allow.
We're not interfering with that 8,064, sir. The tribunal had remanded the matter to the AA only to the extent of taking into account the dealer having deposited rupees 8,064 with the department. Where do you get that narration for that?
Your Lordship,
Paragraph 9.
No, but
Paragraph 9 of the improved order.
Paragraph 9, such contention of the dealer on consideration of the material, Your Lordship, 5 lines below, such contention of the is also not tenable, but so far as the contention that deposit of 8,000 is not.
No, when did that, in what circumstances was that 8,000 deposited?
My concern is
8,000 has been deposited very earlier.
While
giving credit, they have given short credit of 8,000.
After audit, that is.
This is the audit assessment.
It appears that the said amount was deposited by the petitioner soon after the audit visit.
Before audit, my lord. In the return itself, it has been paid. While giving credit, he has given less credit of 8,064. That was not.
Your Lordship may give that. Your Lordship may give the finding that if it has been deposited prior to audit, then Your Lordship at the time of filing of.
So let's not get into it at all.
Your Lordship, because the tribunal itself says.
Does not wish the
tribunal itself says
Your any further as far as that part of the order of the tribunal is concerned, and it is not being interfered with. However, the order of the tribunal, to the extent it upholds the demand raised on the SSC dealer, of VAT of rupees 376,458 is concerned, it is hereby set aside. Correspondingly, the penalty amount under section 42 bracket 5 of the Act of the OVAT Act is also hereby set aside. The questions are accordingly answered in favor of the assessee and against the department. The petition is disposed of.
Item 71.
Allowed.
Disposed of, sir.
Oh, sorry. Sorry.
Item 71.
Sorry.
May I please minutes. The questions of law, my lord, is at page 6 of your lordship's brief minutes. Because questions number B, C, E and F, my lord, would be relevant for your lordship's kind consideration. But if your lordship would accept questions number B
Can it
and
be
C.
next week?
All right.
No, sorry.
No, if you're issuing notice, then it can come even later. What are the questions?
Questions, my lord, at page 6. Relevant would be, in my humble submission, question number B, whether the tribunal was justified in restoring the order of reassessment
Or
undisputedly.
will you say notice? He accepts notice and notice confined to question B, we'll say.
No, B, C, E and F.
No, C, B and C the same thing, sir. All of this is the same,
No,
reopening.
E and F. Reopening is 2 questions. So far as the rate of tax applicable, my lords, to spare parts, that is E and F.
All right. B, E, and F. Confined to questions B, E, and F. Raised at pages 6 and 7 of the paper book. He accepts notice. List on 16th November. Right.
There's an
List
interim,
for orders, item 72.
there's an interim application.
That's okay.
Oblations.
Item
16th
72.
November.
72.
My lord, I am appearing on behalf of Mr. Dayananda Mahapatra, counsel for Bhubaneswar.
All right. None appears for the petitioner. Dismissal not possible.
Wiki list, item 73.
None appears. Dismissal not possible.
Wiki list, item 74.
None appears. Dismissal not possible.
74, your lordship, it is a dispose of case.
That MC number. Right. None appears for the applicant. Dismissed. Same here. 73 also MC. All these are MC cases. 74 also MC case. None appears. Dismissed.
75.
Again MC case dismissed.
Become infructuous.
Constantly the applicant states it has become infructuous. It is disposed of.
Wiki list for admission, item 76.
76, I find, but the cause of action so far this grievance is concerned no more survives. If there is any further lifting of hand,
All right. Counsel for the petitioner states that the cause of action does not survive, and that if any fresh cause of action arises, the petitioner will seek appropriate reliefs. The petition is accordingly disposed of.
Much obliged.
Wiki list, item 77.
77 infructuous. Counsel the petitioner states the petition has become infructuous. It is disposed of as such.
Wiki list, item 78.
None appears. The memo is taken on record. The petition is disposed of as infructuous.
Wiki list, item 79.
My lord, 79, my lord. Wrong file has been tagged to this writ application. That is 14,941 of 2016. My lord, 2018 file has been tagged because in that case, my lord, counter and rejoinder, everything has been filed connected to same issue, my lord.
What's the issue, sir? What is the issue?
My lord, issue here, my lord, the declaration of my lord, so far as the my lord Konark Balkhand, my lord, sanctuary is concerned, my lord. My lord, though it has been notified, but it has not been, my lord, finally notified. So therefore, my lord, the notification by the environment is illegal.
So only defects, sir.
My lord, it will be removed, my lord, within 3 days.
All right. Mr. Raut says the defects will be removed within 2 weeks. List along with repetition 14941 of 2016 on 19th October. Right.
Obliged, my lord.
Weekly list item 80.
Please, your lordship, I am appearing on behalf of Mr. Mukherjee, who is on his legs, my lord. I am BC, my lord. This is a PIL which was sent by the Honorable Supreme Court to be registered as a suo motu regarding police reforms and to implement the guidelines of the Honorable Supreme Court as to how the police should act during demonstrations, agitations, hartals, and the filling up of vacant positions in the police forces and the guidelines for media reporting, my lord. And we have also filed a report, it is flag Z. In the meantime, the Orissa Staff Selection Commission had filed a counter. There are huge vacancies. They are to file a fresh counter since this matter is coming after a long time. And also we had, my lord, at page 5 and 6 of our report, we had prayed for a direction that disciplinary action may be taken against the errant traffic police officials who allowed a bike rally without helmets, where the common citizens are being fined 1,000 and more than that, but political persons, they are free to roam without helmets, and police actively supports them. We have given a photo and a newspaper cutting at page 6. But
what is the actual scope of the petition, sir?
My lord?
Police reforms, right?
Police reforms, yes, my lord. And the violation of statutory rules during agitation, demonstration, hartals, and recovery to be made by the persons.
You kindly see page 2, internal page 2 of the order of the Honorable Apex Court, that is the order dated 11th March 2019. From the material and record on the orders passed by this court from time to time, it appears that one of the central issues canvassed till date is the filling up of large number of vacancies in the different posts in the police forces in the state.
So let the Orissa Public Service Commission file a report. You say an updated status report be filed by the Orissa Staff Selection Commission.
Yes, I have already filed. Well, I am from Staff Selection Commission. In 2019, I have immediately filed after your lordship's order. I have filed an affidavit indicating the vacancy position. All these things.
You file it now, sir. You file an updated affidavit.
Yes, after 2022. Yes, miss.
Yeah.
Done some time, we'll file.
Regarding the filling up of various vacancies in the police force in Orissa. The affidavit be filed for the next date. List on 19th October.
Weekly list item 81.
The notice has been requisition filed by registered post instead of some speed post mailer. That may be accepted notice may be issued.
What's the matter about, sir?
And there is a PL matter. The opposite party number 7 is taking 33 QD connection, violating the provisions and
no. What is that? Opposite parties of 7 is
the Pro Minerals Private Limited.
See, you can go to the National Green Tribunals, permitting the petitioner to go before the National Green Tribunal. In accordance with law, the petition is disposed of. Right.
Weekly list item 82.
This is a serious matter, my lord, concerning the life of emergency fighters for democracy and constitution. We just seek the list from the state government, and that is not coming since 3-4 years.
What? You're not getting a list from the government?
No.
Emergency prisoners.
No relief is sought for. They only want that list. They can obtain, I think, under the RTI Act.
No, we have all those.
When did you file an RTI?
Why? There is no disclosure that you had applied under the RTI Act, and that was.
Where is your RTI application?
RTI reply is there, sir. All are evasive. 30 districts. Everybody has told that no.
And that is not annexed, I think. Is it annexed?
It need not. I have written to your chief secretary. Kindly see with the annexure 1, my lord.
last lines.
No, but
I have requested the Chief Secretary to consult all the departments and give us the list so that even private players will come to the rescue. They are dying every day, every alternate day.
No, they are dying means you know who they are.
Yes, I have a list.
Where is that?
Not,
where is that list?
Authorized list, my lord.
Huh?
That will not be authorized list.
No, they can confirm to you from that list which are.
We had given it to the.
If you have a list, give it to them. If you have a list, you give it to them, they will confirm which of them are.
We had already given it to the finance minister. Kindly.
You have not even placed it on record.
No, sir.
There is nowhere it is mentioned in the writ petition or in the annexure that they had applied under the RTI Act and it was rejected.
Yeah, where have you said, sir? You went under the RTI Act?
Not necessary.
No.
Oh.
You are bound, you are determined not to give the list.
I don't.
Where have you asked? You have to show us the letter where you asked for the list.
Annexure 1, my lord.
Letter to Chief Secretary. No, under the RTI Act, where did you apply, sir?
Since 6 years. 1914.
No, you have to apply under the RTI Act, sir.
May I come with a
better petition. Yeah, counsel for the petitioner appears in person, seeks leave to withdraw this petition with liberty to file a better petition. In accordance with law, disposed of is withdrawn with liberty as paid for. All right.
Weekly list item 83.
None appears to sustain.
Weekly list item 84.
None appears to
this petition became infructuous due to lapse of time of the.
All right. Counsel the petitioner states that the petition has become infructuous, disposed of as such.
Weekly list item 85.
85 of the petitioner in this case. It's a PL application. Your Lordship may kindly turn to page 19. Annexure 2, page 19.
Nolia families.
Well, here in this case,
there's a representation.
There's a representation which is at annexure 7,
all right.
29. The only grievance, if your Lordship turns to one page, my lord, page 36.
No, but what is that to show? This was delivered to the opposite parties. The representation.
Pursuant thereto, they have acted upon the representation. Page 36, only my one page, page 36.
Yes.
It was a letter written by the additional district magistrate Ganjam Chhatrapur to the additional secretary to the government revenue disaster department. The subject is proposal for rehabilitation of 857 number of Nolia families on the displacement from the village to Ganjam district. Last page is 38, my lord, the operative part. It starts with, it may be noted here.
No, so what are you saying? What do you want to?
The prayer in the writ petition is like this. After from 1988, the transfer of land started, and till date, my lord, they have not been rehabilitated and not given the benefits of the RNL policy. And as on date, my lord, in spite of rehabilitating them, at annexure 9, eviction notices were issued. Therefore, the writ was filed in the year 2020. As on date, there has been no rehabilitation so far as these families are concerned.
You want to examine this?
Please, Whereas I'll take
counsel grievance made by the petitioner is that 858 Nolia families displaced from Nuwa Gugolabanda in village Kirtipur in Ganjam district, 857 you say, are yet to be rehabilitated properly, despite an assurance held out, as reflected in a letter dated 1st June 2016 from the district collector and district magistrate Ganjam to the additional secretary to the government revenue and disaster management department. Bracket annexure 8 series bracket. Notice Mr. Mohanty accepts notice on behalf of opposite parties. 1, 2, 3. Mr. Party accepts notice for 4 and 5.
I think 5, I have to take notice, my lord. For opposite part number 5, I made permitted to take notice because.
Yeah, you do it. Replies be filed within 8 weeks, rejoinder for the next date. 13th October.
Weekly list item 86. 86.
None appears justice now.
Weekly list item 87.
None appears justice now possible.
Item 88.
My lord, in item 88, opposite party number 1 on the earlier date stated to file counter, but not yet filed, my lord.
But I am for appealing for OP note 2. I have already filed counter, my lord.
Yes, my lord.
Number 2, in fact.
Opposite party number 1 has not.
Millards, opposite party number 1 is the department, Millards. The issue that has been raised pertaining to Millards illegal slaughterhouses and reforms there too, Millards, that will come under the jurisdiction of BMC, Millards, which is opposite.
We've already asked BMC to file an affidavit.
They have filed, Millards.
Already filed my counter. And allegations have been denied, my lord.
No. What about the state government?
Please, Millards.
Why is the state government not filing?
Millards, we'll file, Millards. We'll file that contract.
BMC has filed an affidavit. The government, Mr. Mohanty Learned Counsel for the state seeks and is granted 4 weeks to file reply. Rejoinder to both affidavits be filed the next date. 18th October.
Weekly list item 89.
None appears this was not possible.
Item number 90.
None appears this was not possible.
Item 86, appearance of Union noted by.
Yes.
One pass one. Weekly list pastor matter item number 12.
May it please, Your Honor. It is a case where the petitioner is the airport director. May I audible, man?
Yes.
And the challenge, the order of the Learned Central Tribunal. The CGIT has passed the order. That I cannot conduct, my lord. That's why I pay some time. The case, I have to hand over the concerned department and they will engage some other counsel, my lord.
Oh, Mr. Party states that he is unable to continue to appear for the petitioner and will request the petitioner to make alternative arrangements. Add its request list on 21st September.
Supplemental list.
My lord, interim order to continue, my lord.
I don't know if there's an interim order, sir.
I have been noting that same thing. It's a long track. It's coming.
Interim order to continue. All right.
Supplemental list item number 3 submission item number 1.
May please the lordship. Here the petitioner is a sarpanch under the schedule area. He has filed resolution and objections, and lordship kindly have glanced to the inquiry report and the report of the excise commissioner at annexure 7, page 26, my lord. At page 26, in exercise of power under Rule 31 of Odisha Excise Rules, public objections are invited from the local public on the said proposal, both Odia and English. As per section 27(2) Odisha Excise Act, another notice was also issued to the concerned Gram Panchayat, giving 30 days time to submit their decision. In response to the above notice, 3 objection petitions were received against the proposal from the local sarpanch and inhabitants of Jharigaon. A Gram Sabha resolution has also been passed by the Gram Panchayat, Jharigaon, which is against the proposal. The concerned inspector excise was entrusted to inquire into the resolution, who in turn has reported that the proposed answer may invite breach of peace and tranquility in the surrounding area. Earlier also the
license has already been issued.
No, that under annexure 8 the government has sanctioned. Lots of kind of glance
You are
section
appearing
20.
for that opposite party 5.
Here also I have been arrayed as OP number 5.
You have got the license or not yet?
Today morning I have got the copy of the writ petition.
So why have you got license? Or
Lords, not the
A
license.
legal license, my lord.
You're running the shop.
License, the shop has already started functioning.
Lordship, kindly glance section 27. I have annexed. Page 30, annexure 10. Even if it will be granted, it can't have any effect. Lordship will 27B. A says, in no case there shall be granted under this act any license for manufacture, possession, sale, or in exclusive privilege for manufacture, sale of any index, except with the prior approval of the concerned Gram Panchayat according to the Gram Panchayat. No license or exclusive privilege which is granted in contravention of clause A shall have any effect for the purpose of this act. So, my lord, even if license is granted, also it has no effect. In view of since Panchayat has not given according to the concurrence of Gram Panchayat and approval.
Yes, Mr. Monty.
All the objections were duly considered by the excise commissioner. What I find from the impugned.
No, this is the Gram Panchayat, sir.
Sidle area, Lord. Sidle area.
And that Sarpanch himself had lodged a complaint.
It's all right.
That was also taken care
Monty
of.
accepts notice for opposite parties 1 to 4 and Mr.
OP5 I have entered.
But I have
through
served.
caveat.
I have already served. Copy.
For OP number 5. Replies we filed within 4 weeks, rejoinder for the next date. It is directed that in IA number 9013 of 22, say the court is informed that the IMFL on shop in question is already operational. It is clarified that this will be subject to the outcome of the petition.
Pardon?
Be subject to the outcome of the
petition. But my lord, 27B says it has no effect, my lord. Section.
We'll have to go into that, sir.
Lord, commissioner.
Running shop, it is a running shop. Let it continue. If the restriction will be allowed, it will be.
Lord, after receipt of the license, also Sarpanch met with the collector and he has given also another representation after the grant also.
Lordship knows that 33.
That will be granted the final relief at the interim stage.
Lordship,
So let the pleadings come in.
The Annex of 4 never translates, my lord. It was a resolution. It is a monthly meeting, my lord.
You file your reply, sir.
Yes, ma'am.
So, commissioner has written everything, but government has granted a license without taking into account that. And Lord, relaxed. The relaxed also, school is there, Lord, hostel is there.
14 September.
My lord, oblige.
Supplementary list item number 2.
Well, it's item number 2 and 8 may be taken up together, my lords. My lords, here, my lords, some admitted facts are there. There was a search. I guess your lordship are not exhausted.
No, it's okay.
A very arduous task. My lords, admitted facts are like this, my lords. In 27th of May 2014, a search was conducted in the assesses of business premises. Assessi is a diagnostic center, having a diagnostic center at Ganjam, my lord, Berhampur. There was no incriminating materials, my lords, unearthed during the course of the search. Now, basing on a statement which was recorded 2 months after the search of the partner of the this diagnostic center, the assessing officer initiated the assessment proceeding under section 153A. And your lordship is aware of the judgment in Mita Gudgutia that a statement of a witness cannot be utilized for the purpose of making a search assessment. That is your lordship judgment, 396 ITR. I have also enclosed. They don't. Now what? He completed the each year's assessment starting from 9-10 to 15-16, my lords, separately. And I preferred appeals. Lordship will kindly see the appellate authority, my lords, that is Annex 3, page 4, it starts in a tabular form. He has at page, I'm taking your lordship to that relevant page, that is at page 38, ground number 4 and 5.1. In this ground, the appellant has stated that incriminating documents were not found during the course of the search, and therefore assessment made under section 153A of the IT Act 1961 is erroneous. It is seen from the assessment order that the assessing officer has relied upon the following incriminating materials. Thereafter, my lords, in the tabular form, he has stated what are the incriminating materials. 9-10, statement of Devasis Padi, 15/7/2014, that is after 2 months of the date of the search. Statement of Vijay Kumar Ponda, accountant, that is third person, 28/5/2014. Then, my lords, again 2010-11.
So why has the revenue come in appeal?
Well, a revenue came in appeal of the judge, order passed by the tribunal by the Annexer 1. Annexer 1, my lords, there the tribunal, though lordship will kindly see at page 11, has stated the grounds taken by the assessee that there was no incriminating material. The tribunal allowed the appeals on the ground that the the assessment was dispersed after the period of limitation.
No, that's true. But against that, the revenue is an appeal.
Revenue is an appeal, and I am also in appeal.
For what?
I am in appeal, my lords. The tribunal ought to have decided the core ground, that is, in absence of any incriminating material, the initiation of the search assessment proceeding.
No, but if the tribunal has allowed your appeals,
allowed my appeals,
then how can you be aggrieved?
Well, I am aggrieved because of the non-consideration of the order of the tribunal by the tribunal, my main ground. That is why I am in appeal, my lords.
Sir, I'm not able to understand. If the appeal has been allowed, where's the question of non-consideration of your main ground?
Main ground, my lords, that is
which means your appeals are very badly delayed.
Yes.
Yes.
1373 days. 1373 days.
My lords,
you've woken up very late, sir.
I have, my lords, sometimes the assessee, your lordship will appreciate. I am ready to, because this is a very jurisdictional issue, and because of the judgment of this Honorable Supreme Court, that is, I have given it, para 31-32, that the jurisdictional issue can be raised at any time, my lords. Lordship may...
No, your jurisdictional ground was that it is beyond the period of limitation. No.
My jurisdictional ground is that the tribunal did not take into account that in spite of non-availability of the incriminating material, the search assessment proceeding is illegal, initiation of this.
And first delay is 51 days, is it?
That is their delay. That is their delay.
All right. Let's see what he says, why his appeals should be admitted.
Yes.
That my question of law is that whether in the fact and circumstance, page 11, whether in the fact and circumstance case in law, whether the Honorable ITAT is correct in observing that the assessment order under section 144 reads with section 153 of the IT Act dated 30th/12/2016, received by the SAC on 9/1/2017, could be said as barred by limitation, when there is no indication as to show that the assessing officer did not pass the said order on 30th/12/2016. Second question is that whether on the fact and circumstance of case in law, the learned ITAT is correct in holding that when there is two, the average view of different high courts on favoring the SSC should be followed, totally ignoring the fact that the decision of the high court favoring the revenue was confirmed.
Anyway, that's all. So what is the factual position of this 30/12/2016?
Yes.
What is the factual position?
And in tribunal, only last line, page
Lord,
25.
Kindly see
coming to
page 21 of the tribunal order, my lords. 21. Before us, the assessee produced copy of the envelope by which the orders of assessment were sent to the assessee by the AO, and copy of the track record of the speed post to show that the improved orders of assessment in fact dispatched by the AO on 7/1/2017. Though the orders were dated 30th of December 2016, the assessee contended that the orders were dispatched after 30th of December 2016. Therefore, the orders of assessment were barred by limitation. He placed reliance on the decision.
This is correct, sir. This is correct.
Yes. And the second one, my lord, that is very important. On the other hand, para 9, the learned DR could not explain when the orders were prepared on 30th of December 2016 and why it could not be dispatched on 31st of December 2016, my lords. This is the factual finding of the tribunal, my lords.
So Karnataka, Kerala,
yes.
Jodhpur,
yes. Jodhpur is the bench of the ITAT, not of the High Court.
And Calcutta.
Yes.
I am giving the judgment of the Calcutta High Court, where the Calcutta
There the facts are different.
No, same. Binani Industries Limited versus Commission on Income Tax Calcutta filed appeal and that been dismissed. And just filed before the Supreme Court, that also dismissed.
There the facts are different.
No, same case. Because on the basis of page
so the mere dismissal of an SLP is not affirmation of the order.
Page 15.
That is settled, sir. Mere dismissal of an SLP doesn't mean the order is affirmed.
Yes, in the page 15, paragraph 15, page 25, in view of the above clinical decision, we are considering opinion the decision of Kerala High Court relied upon by the CIT appeal in the case of Binani Industries Limited will not deter as a settled positional law when two same. So for this, we have derived support of the decision on Supreme Court's digital. But the Kerala High Court, Commission of Income Tax versus Binani Industries Limited, the department appeal is allowed.
No. Just see this para 5 of that Calcutta High Court judgment.
Yes, ma'am.
Please see the Calcutta High Court judgment.
Yes. It appears.
Actually, page 4 onwards, sir.
Yes. It appears from the order of the tribunal.
Yes.
Of the tribunal, the representative of the SSC has filed an affidavit, which he has said that he has served with the assessment order on 13/4/2005 when he visited the office of the Income Tax Department. It further appears from the said order, the CIT-DR was confronted with that affidavit and asked whether the assessment order left the control of the assessing officer or his office as on 31st March 2005 or not. The CIT-DR stated whatever records were available, he had produced, which record did not contain the dispatch register. On further inquiry, the CIT-DR opinion that once the assessment order, including the demand notice, was served on the SSC on 13/4/2005 by hand, there was no question of any entry in the dispatch register. These were the facts on which the respondent SSC has based on its challenge before the tribunal, where before the evidence to show that the
probability of the order being made and ready to be collected as on 1/4 cannot be ruled out. So there was no dispatch. On the facts of the Calcutta case, there was nothing to show it had ever been dispatched. The Calcutta High Court is saying, therefore, it would have been ready and could have been collected on 1st April.
But the judgment is favorable to the revenue miller.
No, correct. On what facts? Because there was no dispatch by post. In the Calcutta judgment,
by hand.
There is no, yes, it is delivered by hand, sir. Hand. So it is here, it was dispatched by post.
And the learned DR could not place any material.
Absolutely. You say these appeals, you say delay condoned in all these appeals by the revenue. the challenge is to an order dated 25th January 2018, passed with Income Tax Appellate Tribunal. Cuttack Bench Cuttack, bracket IT80. In ITA, SS numbers 32 to 37, oblique CTK oblique 2018.
ITSSA, income tax search.
Yeah, SSA only.
Yes.
32 to 37. For the assessment years 2009-10 to 2015-16. The question sought to be urged by the revenue for consideration by this court are as under. Take from page 11. Paragraph. The facts in brief are that a search was conducted under section 132 of the Income Tax Act 1961 bracket in the case of the opposite party SSC, respondent SSC on 28th May 2014. Pursuant thereto, an assessment was completed under section 153 capital A, read with section 144 of the Act for the aforementioned AYs on 30th December 2016. Paragraph. Relevant to the first question sought to be urged, the facts are that the assessment orders, according to the SSC, were dispatched by the assessing officer, bracket AO, only on 7th January 2017 by post and was received by the SSC
on 9th January.
On 9th January 2017. Stop. Contending that the assessment orders had to in fact be served on the SSC on or before 31st December 2016 and were therefore time barred, the SSC assailed those orders before the CIT, before the Commissioner of Income Tax bracket appeals, apart from other grounds. Full stop. However, the CIT bracket A observed that since the orders, assessment orders were dated 30th December 2016, and the absence of any material to show that the AO had revisited those orders thereafter, the CITA upheld the orders relying on the decision dated 19th November 2014 of the Calcutta High Court in IT 18 number 54 of 2014, bracket GA number 1637 of 2014, bracket Commission of Income Tax Central 1 versus Messrs. Binani Industries Limited, bracket. Oh, this is a citation. 2015 59 taxman.com 389 bracket cal. Paragraph. However, as far as the present case is concerned, the opposite part, the respondent SSC could produce before the IT-80 copies of the envelopes in which the assessment orders were dispatched by the AO and a copy of the track record of speed post, which showed that the orders were in fact dispatched only on 7th January 2017, although they were dated 30/12/2016. Full stop. Relying on the decision of the Karnataka High Court in CIT versus BJN Hotels Limited, 2017, 79 taxman.com, page 336, bracket Karnataka. K. Joseph Jacob versus Agricultural Income Tax Officer, 1991, 190 ITR 464, bracket Kerala. Commissioner of Agricultural Income Tax versus Kapumalai Estate, 234 ITR 187, bracket Kerala. And the IT-80 came to the conclusion that the orders of assessment had to be made on or before 31/12/2016. And since they were dispatched only on 7/1/2017, they were time barred. Paragraph. Mr. Chimanka, Learned Counsel for the Revenue, places before the court copies of the orders of the Calcutta High Court as well as an order dated 20th November 2015 passed by the Supreme Court of India in SLP Civil 8397 of 2015, filed by Messrs. Binani Industries Limited against the said order, dismissing the specially petition in limine at the first date of hearing. Full stop. It is accordingly submitted that the ITAT ought to have followed the judgment of the Calcutta High Court, which favored the revenue, and not the decisions of the Kerala and Karnataka High Courts, which were against it. Full stop. Paragraph, as rightly noted by the ITAT, the requirement under section 153 capital B bracket 1 is for the AO to make the order of reassessment within a period of 21 months from the end of the financial year in which the last of the authorizations for search under section 132 of the Act was executed. Full stop. In the present case, there is no doubt that the last date by which the assessment order had to be made was 31st December 2016. Full stop. As further rightly noticed, section 153 capital B bracket 1 uses the word open quotation order of assessment unquote and not merely single quotes assessment. Full stop. The order becomes an order only when it is in fact communicated, and therefore the communication of the order had to be prior to the end of the limitation period. Full stop. In BJ and Hotels Limited, the Karnataka High Court held us under. Take from page 24, running page 24 of ITA 150 of 2018, the last two paragraphs. Paragraph. On the other hand, the judgment of the Calcutta High Court did not involve any dispatch of the order by post at all. The following passage in the said judgment reveals that the order had been kept ready in the office of the AO, and the representative of the assessee came there to collect it. Full stop. When the full stop, the assessee, the order had to be passed. The order was passed on 31st March 2005. The last date by which it had to be made, and the AR of the SSC visited the office of the department and collected it on 13th April 2005. Full stop. When confronted, the CIT produced records, open quotation, which record did not contain the dispatch register, unquote. The Calcutta High Court then concluded from the oral evidence of the CIT. This is A to A, is it? A to A. Consequently, the Calcutta High Court proceeded on the basis that there is no attempt at dispatching the assessment order at all, and therefore it was kept ready to be collected by the AR of the SSC from the date it was made ready. Paragraph. The facts are therefore clearly distinguishable from the case on hand, where the postal envelopes clearly show that the dispatch was made only on 7th January 2017 by speed post, with the tracking report showing this, as well as the fact that it was delivered to the SSC only on 9 January 2017. Therefore, notwithstanding that the Supreme Court may have dismissed the special leave petition against the said order of the Calcutta High Court in limine, the said decision is not of any assistance to the revenue as far as the present case is concerned. Paragraph. Consequently, the court is satisfied that no error has been committed by the revenue in allowing the SSC's appeals. No, the court is therefore not persuaded to frame the questions of law as urged by the revenue. The appeals are accordingly dismissed. Paragraph.
Number 8 is also to be dismissed, my lord.
Sorry?
Item number 8, SSC's appeals are to be dismissed.
All those appeals, there are how many appeals? 8 onwards, no?
Yes, my lord. 6, yes.
These are appeals directed against the common order dated. These are appeals by the SSC against the common order dated
Tribunal order.
16th May 2018 of the IT-80 Katak bench in IT SSA number 332 to 37 oblique CTK oblique 2018. Only on the for the AYs 2009-10 to 2015-16. Only on the ground that the additional ground urged by the SSC was not considered while allowing its appeals. Full stop. Today, by a separate order in ITA numbers
Item 2,
150 to 160 of 2018 by the revenue, this court has affirmed the aforementioned order of the IT-80 and dismissed the revenue's appeals. Consequently, the present appeals are also hereby dismissed.
Though these appeals have been filed for material
statistical purpose.
Much obliged, my lord.
Supplementary list item number 3. Item number 3, my lord. My lord, in this case, petitioner challenged the virus of granting error of 1994, my lord. My lord, in order to approve their appointment, my lord, as per the Prafulla Sahu case and Chittaranjan Mahapatra case, my lord, and similar matter has been posted to 16/11/2022, my lord. So let it be posted to that day, my lord, for hearing, my lord.
Anyway, list on 16/11/22.
Yes, obliged. Supplementary item 4.
May I please, sir? Item 4, today we received the copy, sir, my lord, and Mr. Satpati is busy in his Sarat ceremony of his father. It may be taken up some other day. 4, 6, and 18.
Notice is already gone, right? Has notice already gone, sir?
No notice. The first time came up. This case first time.
What is the plea here, sir? What is the point here?
Point here is it has been challenged. The assessment order, consequential penalty order, all has been challenged because originally 143(3) assessment was held. Thereafter, after 3-4 years, 263 proceeding was done. And here we are challenging 144 capital B amended act, where no so-called notice and no draft assessment order was provided. So for quashing all these orders, this writ has been filed.
These are after the act came into force, the amendment came into force.
Yes. At the time of passing the order, it was in force.
No, but after the judgment in the Supreme Court,
Yes, ma'am.
the amended provisions are prospective, sir.
Yes, ma'am.
Then where's the question of draft assessment order?
My lord, in fact, this case has been filed by me, but it will be argued by Mr. Bej from New Delhi. He has undergone a heart surgery.
You say at the request of counsel for the petitioner, list on. When do you want it, sir?
After at least a month. He has undergone a heart surgery.
All right. 29th August. All right.
Oblast.
Supplementary item 5.
Right, my lord, I pray for 1 week time for removal of defect, my lord. I am busy.
Defects we removed within a week. List thereafter.
Supplementary item 6.
May I please, your lords? Advocate on behalf of the department requested me today that his father Shraddha is there today, so he could not able to come to the court. So request for one adjournment.
All right. List say 29th August. All right. List on 29th August.
Supplementary item note 7.
Well, item 7, I am there, my lord, if your lordship permit.
Yes.
The commissioner actually set up a fertilizer plant in Paradise, and it came to commissioning on 16/4/2000, my lord. But in fact, they have got the benefit of IPR as per the government's declaration, as per IPR policy number 1996. But if your lordship turn to page 20, clause 8.
All right. You just issue notice. You say notice. Mr. Mudali accepts notice for
order.
All right. Replies we file within 8 weeks, rejoined up for the next date.
But the interim stays because the entire thing depends on the certificate that is to be granted in my favor.
So you pay whatever you have to pay subject to the outcome, sir.
But actually, I have already paid 3 crores.
That's all right, sir.
Just order of the Honorable High Court, my lord. But I have paid. But if your lordship kindly see page 47, they granted the eligibility certificate of sales tax. Now the only thing they have to grant is eligibility certificate with regard to electricity, which is energy, which is they are supposed to give because the production certificate already granted.
No, the certificate case number 2 is for what? Certificate case has been filed for recovery, right?
Certificate, actually, the electricity department says until you get the benefit of eligibility certificate, we are ought to demand. Therefore,
this you're asking for stay of some certificate case.
Yes, my lord.
Pending in the collector's office. So what is the amount you have to pay there?
But amount actually it is about if your lordship turns to the certificate.
About 20 crores.
It was 3 crores at the relevant time.
29 crores, 96 lakhs.
No, but that certificate case.
If your lordship kindly.
Not even on record, Mr. Mishra.
Yes, my lord.
Page 29. Page 29.
Page 29, if your lordship looks at.
Annex 2.
29 crores.
Yes, now actually multiplied with interest.
This was in 2005, sir. What has happened since then?
No, that was stayed. Your lordship stayed it in the previous rate application, it was stayed. But now the question is because the amendment was objected to, therefore I have to file a rate application. It was stayed till the only last week. So the moment actually it is granted, and I'll get the benefit, my lord. There will not be, I am not liable to anything at all. It will be.
Where have you said there was a stay, sir, in the previous writ petition?
The previous writ application is stayed. If you also kindly turn to the previous order. Kindly turn to your lordship's order dated 21/6, my lord, at page 11. The interim order dated 22nd March 2007 has worked itself brought to an end. Page 12. 22nd March 2007, the stay was there. Because your lordship disposed of the matter, it has worked out and this been disposed.
No, but you had deposited 2 crores.
Yes, 3
and
crores.
further deposited 3 crores.
Yes. 3 crores I deposited. 1 crore initially deposited, 2 crores subsequently deposited.
So what are the steps they're going to take? That certificate case is not listed or anything, is it?
No,
So if it is listed, you move an IA, sir. We'll just issue notice on that also. All right.
certificate case is
Just
pending.
issue notice. Yeah. If there's any step taken in that, then you can always move an IA. List on 26th September.
You may indicate that I'll move.
All right. In the IA number 8543 of 2022, it is submitted by Mr. Mishra that in the earlier writ petition filed in this court by the petitioner, there was a stay operating against the further proceedings in certificate case number 2 of 2005 against the petitioner. Paragraph. If any coercive steps are taken in the said case, it will be open to the petitioner to file an application for appropriate interim directions. List on 26th September.
Supplementary list for admission item number 14.
Wait, please, Lord. My Lord, the fact is very brief, my Lord. Actually, the government wanted a particular land owned by me. So petitioner got a land exchange, and by exchange he got by Annex 2 registered sell it. He got the land, but the land he got was not actually free from incumbents. So possession could not be delivered. Thereafter, since he requested for an alternative land, since that was not considered, the application has been filed. And when there are two contradictory statements in the counters, this honorable court, Your Lordship, by order dated, Your Lordship, by order dated 25/10/17, directed appointed advocate commissioner for inspection of the land and give a report. Last occasion, actually, the report was not there, and in the report has come. Flag X, my Lord, Lordship, kindly see.
Mr. Mohanty, you've seen the report?
Yes, I have not seen, but we are producing a report prepared by the GA department as has been directed by Your Lordship in the last order.
So far as our land is concerned, Lordship, kindly see page 7. This inspection, this done was in presence of GA staff and other staff, my Lord, all the government staff. My Lord, Lordship, kindly see page 7 of the report. This related to my land because the other up to para 10 mallet relates to the land which involves the other petitioners. We are no way concerned.
That is not.
Where is your report?
This is my report.
No, Dayanand
You better go through that report.
I have only one copy.
You don't have Mr. Mahapatra's report?
No.
Then how can that is
the copy of the joint report prepared by Mr. Mahapatra and Mr. Siddharth Mishra.
Yes.
Dated 24/12/2017 be provided to Mr. D.K. Mohanty.
And I will also serve copy of my report to them.
Upon his paying the usual charges. The report today submitted by Mr. D.K. Mohanty be served on Mr. Manoj Mishra and Senior Counsel appearing for the petitioner.
And Mr. D.P. Mohanty.
I have already got my copy.
And Mr.
I have got my copy.
Okay, and on Mr. D.P. Mohanty.
My Lord, report we have got the copy. Report we have got the copy.
Government report.
List on 27 September.
Sorry, my Lord.
27 September.
Oblige.
Right.
Supplementary list item number 15.
27 September.
Item number 15.
None appears to no.
Supplementary list item number 16.
I may be pardoned. Supplementary list item 15.
15.
My lords. May I please, Your Lordship? My lords, here I was the license holder of an off shop, my lords, Lakshmi Sagar off shop, and I have been running the said shop for my lords a period of more than 30 years. My lords, when I went for the renewal of the said license in the year 2013 and 14, my lords, it was I was directed by the collector Bhuvnesh Khorda, my lords, vide Annexure 10, that since the property is based in a HUF, the shop premises was based in a HUF property, my lords, I have to obtain the no objection from all the co-sharers, my lord. My lords, previously this honorable court has been pleased to direct that the said letter be kept in abeyance. My lords, here
Sir, now there's a new policy. Where's the question of any off shop now?
Infructuous, I think, whether he's still
It's all
continuing.
infructuous now, sir. All this is infructuous now.
This off shop is no more
The policy of granting license for off shops has undergone change.
This particular shop is already
Consequently, the
allotted to
course of
somebody
action
else.
For the present petition does not survive. The petition is disposed of.
My lords, may I make one more request? My lords, I had applied for the shifting of the shop premises.
And that is a different issue.
That may be treated on its own merits.
Where is the question? There's no shop now. Is there a shop still?
No, that is what he
Where's the question of
has no
shifting it?
idea.
My lords, I have applied.
Take instructions.
If there is no shop, sir, the policy is changed.
My lords,
There's no
as per
question
my
of shifting now.
instructions.
Yeah, all right.
Supplementary item 16.
15 is over. 16.
Item number 16.
Maybe. My lord, here in this case, petitioners before my lord, as the resident of Badgar Canal Colony at BJP Nagar at Bhubaneswar, since the entire area locality was submerged with rain and diffused water, they have filed initial application seeking direction to the opposite parties for maintenance and construction of drainage and sewerage in their locality. Thereafter, my lord, in this case, the member secretary, the opposite party number 5, entered their appearance.
1 minute. Who's OWSSB?
Lord, Watco is supposed to answer.
No, my lord, Watco has already filed.
My lord, for Bhubaneswar Municipal Corporation area, my lord, the sewerage and has already been transferred to the Watco, my lord.
Watco has filed an affidavit.
Yes, my lord. Watco has already entered their appearance and filed their affidavits and the compliance report. They have stated that they have already constructed the storage board, and now the fact remains regarding the drainage. And this, so far as the drainage is concerned, this my lord has directed, and in this drainage, the opposite part number 1, that Commissioner cum Secretary or Water Resources Department filed an affidavit. Yesterday filed an affidavit stating that enclosing the copy of the notification, wherein they have stated this matter is enclosing a resolution along with a minutes of discussion, wherein it has stated that the opposite part number 6 and 7, that is Bhubaneswar Municipal Corporation, Commissioner of Bhubaneswar Municipal Corporation and this executive, that Bhubaneswar Municipal Corporation is the authority. They have to take care of the drainage.
Yes. Yes, my lord. Bhubaneswar Municipal Corporation and Watco, my lord. So, my lord, in fact, my lord, my learned senior Mr. Bhunya is there, my lord.
No, my lords, in the last occasion on dated 9/5/22, my lord, that is this one of directed the opposite party 1 to 3 to file their counter, my lords. Now that's only the storage work they have already completed, and we have also filed our counters. Only now it is the opposite from 1 and 3, they have also filed a counter. They say that the Bhubaneswar Municipal Corporation.
Who's for BMC, sir? Are you BMC?
What is not doing the drain work?
No. Who's for the BMC?
Only there only storage work they are from. In fact,
sir, when I ask who's for the BMC, if you start arguing, I'll assume that you are for the BMC. I'm asking who's for the BMC and you are arguing, should I presume that you are for the BMC? Who's for the BMC?
Probably did my knowledge appeared, my lord.
Not at all.
Opposite party number 7.
The court is informed that the responsibility as far the drainage work is concerned is that of the BMC, the Bhubaneswar Municipal Corporation. None is appearing on its behalf today. The registry will inform Mr. Dayananda Mahapatra, who usually appears for the BMC, to remain present. He appears, right?
Mahapatra, you here.
BDA.
BMC.
No, BMC is who?
Mr. Manas Mahapatra, senior advocate.
There has to be some advocate on record, sir.
It's a PK Mahant.
I'll inform them. They will engage somebody.
All right. For appearance of the counsel for the BMC, list on 10th August. Right.
Supplementary list item number 17. Lord, wait, please, Lordship.
My lord, the appellant in
It's
the,
already 4:30, sir.
no, Lordship may take it some of that.
List on.
Your Lordships have dictated 60 judgments. That is what.
List on. We become a machine, I think. 21st September.
Deeply obliged.
Supplementary list item 18.
Lordship, the matter may be taken up some other day.
Yeah. List on 19th October. Right.
Lordship may discharge the vote for the day.
Supplementary
No, only few left. So
item 19.
19, your Lordship may call it some other day. I'll file a rejoinder in the meantime.
all right. 18th October. All right.
Supplementary list item number 20.
20 we'll have to have a sub.
No, well, I only think item number 20, what has happened is they are filing a response to the reply which was being filed by Watco. Therefore, they are giving us a copy of the rejoinder affidavit now and also a pen drive wherein the audio recordings are there. I have not checked it. Now they are
Who's
giving it.
they?
So they are filing now.
No, who's they?
The opposite party number 10 is filing this.
It is stated that.
I'm just handing.
Okay, opposite party number 10 has handed over an affidavit along with a pen drive, copy of which has been given to the learned amicus curiae. All right. List on. Give me that. 16th August, sir.
Oh, place lots.
Supplementary list item number 21.
Last time you noticed that to file affidavit.
21. Today I'm filing the affidavit. I'm also serving a copy. See, regarding construction of road, you can see paragraph 4. You also get the last page. Last page stop.
To be completed by 9/12.
Yes. Well, in fact, the complete stretch is up to 2040 meter. Out of that, cement concrete pavement with dry lean concrete as base layer that has been completed, and out of that, 150 meters of dry lean concrete.
Anyway, an affidavit has been filed by opposite party number 4, in which inter alia it is stated that the entire project work will be completed by 9th December 2022. To monitor the progress list on 14 November.
Supplementary item 22.
28th of January 2022, you have issued notices. Counter is to come.
Receive the draft counter. It can be filed very short date. Let's make give 10 days time. Item 22. 2 weeks. Item 22.
PK Party says that he's already received a draft counter affidavit. He assures the court that he'll file the counter affidavit on or before 8th August 2022.
Within 2 weeks.
Yeah.
No, because you
list on 23rd.
State
List on
is also to file a counter.
Originals also be filed before that date.
Well,
List
in
on
fact, this
30th August.
original application was dismissed on the ground of delay latches and for non-gender of necessary party.
All right. Right.
Supplementary item 23.
Mr. Satpathi's name may be recorded along with me. 22. There was
item 20.
23, my lords, on behalf of Mr. Prashanta Sen, may be taken up any other day.
All right. List on 28th September.
Supplementary item 24.
Well, it's item 24. Well, it's on behalf of
last occasion they have been asked to take
opposite
instruction.
party number 3, my lords. Probably notices have to go because executive officer NSC, my lords, they have different.
They have handed over the land to the PWD already. The land has already been handed over. Just a upgradation of the particular stretch of the road.
Is that
my small prayer is that a direction may be taken to upgrade the road within a stipulated time. That is my limited prayer.
What is, you took time for instructions last time?
Please, I haven't received instructions because the instructions have to come from the NAC because NAC has to hand over the land to the PWD and thereafter, my lords,
notice. Mr. Monty accepts notice for 1 and 2. Notice will go to the opposite party number 3 by registered speed post, returnable 16th August. The tracking report will be placed in record. All right.
Grateful.